May I please, proceed with respect to item number 32, with the consent of the other side.
Adjournment.
Maybe after-
STKL respondent adjourned.
Lordship, there is an interim.
Interim continue.
May I please? I would like to mention for listing of motion lordship tomorrow, because the lordship, what happened
Today,
tomorrow,
today,
today? No,
get it. Before the court rises.
lordship.
Okay.
And one more prayer lordship. regarding-
I don't know. Before the court rises, if you can, we'll take it up.
No, regarding item number 8 lordship, some instructions are awaited lordship. Can it be taken up after vacation?
Adjourn on the prayer, Mr. Arthur. Like our repetition.
Chief Lord.
May I please, your Lordship? Back to listing for motion.
Same order, today. Today, before the court rises. If he rise at 11 o'clock, before 11 o'clock, if he rise at 4, before 4 o'clock.
Can you witness the
No. Wednesday, we'll have very less time. Sorry.
petition is voluminous?
I don't know. Wednesday, we'll have very less time. So, if you can bring it, you give it.
May I please, Lordship, I beg to mention item number 31. that is-
31,
Yes, dear Lordship.
adjournment.
Yes,
Your name?
M. Chatterjee.
M. Chatterjee. For whom do you appear?
My
Petitioner
sis-
or respondent?
Respondent.
M. Chatterjee, respondent, Jones. Yes, for petitioner. Yes, next one.
May
Lordship, I beg to mention item number 6, kindly adjourn the matter.
Your name?
R.A. Ahmed.
R.A. Ahmed, petitioner, Jones. Yes,
I beg to mention item number 13 lordship.
13. adjourn. Your name?
RL, my name is not there lordship. Another.
Your name to likhibo, adjourned. Tell your name.
RL state.
Yes, next
On
one.
behalf of DVR.
Bihar CF na lage, eta naam likhibo.
RL.
Yes, please, move over. Let the RMA
Yes,
come in.
Your Lordship,
Yes.
Lordship, I beg to mention item number 4.
Oh,
Adjourn the matter for
your name?
K. Sitya,
K.
K. Sitya Fupan.
K. City of Hukon, petitioner, adjourned. Yes,
Lordship, with due concern of the other side, I beg to mention item number 29, Lordship. I pray for
29.
adjournment.
your name?
M.R. Chaudhary, Lordship.
M.R. Chaudhary, respondent,
Petitioner, Lordship.
petitioner, adjourned.
How
I
like-
beg to mention a writ petition for withdrawal lordship tomorrow lordship.
Withdrawal.
Another prayer is item number 5 lordship.
5.
Adjourn for the date.
Your name? Khalifa.
A Begum lordship.
A. Begum, petitioner, adjourned.
For listing of petition, Lordship.
Today.
Tomorrow.
No.
One day after tomorrow.
No.
Wednesday.
If you have urgency, get it right now.
For before effective, Lordship.
Yes, next item.
Item 1 for motion.
May I please, Your Lordship? In this case, we have challenged the order of removal as a instance principal of the Senga IHS school. Lordship, what happened in the meantime? Lordship?
Our Mojumdar Council for the praise for weeks time to file
But, Lordship, During
affidavit.
the pendency of the requisition, Lordship, regular principal was
Infectious. Mr. K. Kolita Land Council for the petitioner states that the in charge principle given to the respondent number, no respondent.
Lordship,
who?
order of removal. Lordship.
Huh?
Order of removal, Lordship, page 69, Lordship.
The order of removal against the petitioner
As in charge principal.
is assailed in this writ petition. Why it is infectious?
Lordship, in the meantime, during pendency of the requisition, Lordship, the regular principal is appointed.
The your removal.
Yes, Lordship, remove as a in charge principal.
Okay, order of removal as in charge principle is assailed. Huh? In the meantime, regular petitioner, no adjournment required. Closed.
Item 2.
So in this item, I have filed my affidavit. It is been requisition. Today only I have filed it.
Now what do you want? Timing.
Item 3.
Yes, madam, I didn't treat John on the prayer of the petitioner. Hmm,
Lordship, matter regarding the compassionate ground appointment.
sorry,
Matter regarding compassionate ground appointment.
why is it pending for the last almost 1 year? Why didn't you move the petition?
Lordship, due to some.
It was first listed on 6/1/2023, adjourned on the prayer of the petitioner. 11/4/2023, adjourned on the prayer of the petitioner. 27/6/2023, adjourned.
Lordship, due
No,
to
no, compassionate appointment, there is always some urgency.
Lordship,
Why did you waste 1 year of this man?
Lordship, due to some personal difficulties of my senior matter.
Who is your senior?
KR Patgiri.
Sorry,
KR Patgiri.
yeah, Padgiri. So for his personal inconvenience, he'll put your client in jeopardy for the 1 year. And Mr. Padgiri had been appearing before this court for the last 1 year. I have noticed it. So that it cannot be that for 1 year he had inconvenience not to press this matter. Where is he? Ask him to come. See, respondents are having compassion. We are having compassion for compassion. Why you are not having that same compassion?
Item 7.
Your lordship. You will ask about the timing, madam.
Item 9.
Please, lordship.
Mhm.
Lord personal is my lord, handicapped person, my lord, he is, my lord, low vision category, 40% low vision category, my lord, kindly see my lord, the page 24. Disability certificate. And page 25, my lord. Relevant person, my lord, kindly see.
What is your case, Mr. Chavan?
My lord, I have been, my lord, selected, page 29, my annexure E.
Page 29,
37, sorry, 37,
37.
annexure I. my lord. By order date 25/5
Binod
2023, my lord.
Chutia. Bipul Chandra Talukdar.
Yes.
Oh, 37
Is the appointment order of the petition.
appointment order of,
Petition. People Chandra Talukdar.
no. If my page 37 is right, this is regarding Binod Chutia, not Bipul. Come to page 37.
My lord, here, people from the Talukdar.
Petitioner is Bipul Chandra Talukdar. But page 37 appointment order of Binod Chutia.
Previously, there were 3 cases which were tagged together, maybe some misplaced.
We don't know.
My lord,
Mr. Chauhan, you have to explain, you say petitioner Bipul Talukdar was selected, not appointed.
yes,
And for the purpose, you refer to page 37.
yes, my
Look at the name appearing in page 37.
lord, in the people Chandra Talukdar.
Where do you read Bipul Chandra Talukdar?
Left side, my lord. Name and address of the candidate.
এখন দিয়ক শুনতা। Mr. Tegu, please read along with him. Do you notice Bipul Chandra Talukdar name there? Then? The petitioner Bipul Chandra Talukdar institutes the petition on the ground that although he was selected and appointed by the order at page 37, order dated at page 37, but no appointment order had been issued in his favor. But page 37 reflects the name of Binod Chutia Sam Dhemaji Likhidibo. Read petition closed with liberty to file a fresh. Next item.
My lord, I will correct it, my lord.
File
Kindly
it.
allow, my lord, I will correct it, only one page, my lord.
How can you,
I'll correct it, my lord, kindly.
instead of correcting, file a new one, we'll hear you.
My lord, it take time, my lord.
Yes,
Why,
doesn't
I'm
matter.
will-
Next item. please.
Item 10.
I
File a
will
new petition.
correct, my lord.
Yes, next item. We are giving you the liberty. Come, we are not closed your.
Matter pertains to my confessional appointment, my lord. Petitioner is a disabled person. His disability was not at all considered well, considering his case.
Compassionate appointment.
Right.
And where is 40% locomotor?
My lord, page 68. my lord.
Yes, who appears for the respondents? DLC, who appears? Is the Disability Act 4% reservation applicable to compassionate appointment?
No reservation.
There is no reservation in compassionate appointment. So where is the question of 40% locomotor disability for compassionate
That is
appointment?
one ground, my lord. But the LCS considered the other grounds, my lord, which
What is one,
applicable.
what is the meaning of one ground? What do you mean by one ground?
disability, my lord. Disability only special ground for consideration of.
Is
any
it
sort-
applicable for compassionate
No, my
appointment?
lord.
Well, let us see the law.
No, my lord.
It doesn't, is not applicable. Compassionate appointment, no reservation of any kind. Because that itself is a reservation.
Yes, your lordship is correct.
We know we are correct, Mr. Sakia. We don't need your certificate to be correct. What is your case now?
My lord, kindly peruse, my lord, the page 33, my lord.
33,
This case was not considered earlier.
33.
Second table, my lord, serial number 4. In fact, third table, my lord. Serial number 4. The case is considered as not selected on the ground of economic condition, which is better than recommended. How, my lord, they have,
They must have done that comparison.
my lord, there is no mention of that, my lord.
No, they have mentioned it. Law requires comparison of economic condition. They have done it. Then what is wrong in that?
Subsequently, my lord, the petitioner's case was again placed, my lord. Case 41. Serial number 8. Now they have said, my lord, that date of last application is after more than 1 year from the date of, and moreover, he is underqualified. Serial number 8.
Eight.
3 months old.
This one will have to interfere, Mr.
Yes.
Sakia. There cannot be any second application if you. There is only one application if it is within time. If you want to consider again, you consider. No one is stopping you. But don't reject it in this manner.
Like my lord, first one correctly rejected and second again they placed.
Sorry.
First one is my lord, they have correctly.
No,
rejected and
had
second
you
again.
not considered second time, we have nothing to say. But having considered second time, you cannot reject on this ground. See, I may have the option not to allow you to come inside the court. But once you are inside the court, I don't have the option to ask you to go out. Understood? You may not have placed it second time,
My lord.
but once you have placed, considered, you have to follow the law. For that, you have to go back to what else to do.
Along with other ground is also there. My lord.
Both the grounds are not accepted.
This one of qualification here.
What is your qualification?
My lord, he is a higher secondary pass.
Why higher secondary is not qualified for grade 4?
Higher secondary is my lord qualified.
This is wrong. That's why we are saying
10 pass my lord, qualified.
10 plus, some post,
Yes.
some department, even class 8
Even-
pass is
yes,
also
ma'am.
there. So this is a wrong reasoning.
Yes, higher secondary, my lord, that's one.
Heard Mr. P.J. Saikya and Council of Petitioner also P. Saikya for the Deputy Commissioner Lokhimpur, MSS Tutia for Relevant
Morigao.
Education Department, the father of the petitioner.
Tokidar. It is Tokidar.
Who is the name of your father?
My lord, Sukleshwar Bordoli.
Where have you written? Sukleswar. The father petitioner Sukleswar Bordoloi, who was a chokidar in the Botawari MU school, died in harness on 15/9/2012. And on his death, the petitioner made an application for compassionate appointment on, what is the date? When did we apply? Annexure 2, copy of the application. What is the date?
310.
3/10/2012. The said application was initially placed before the DLC of
811.
Morigao.
Morigao district in its meeting of 25/9/2013. And application of the petitioner stood rejected by providing the reason that upon comparison of economic condition with the other applicants, comma, the petitioner was found to be financially better off. We see no infirmity in the reasoning of the DLC. But however, the application was again placed before the DLC
On 6/8,
of, please, Mr. Saikia.
sorry.
Again placed before the DLC of Morrigaon District in its meeting of 6/8/2014. But this time it was rejected that by providing the reason that the latest application was submitted more than 1 year after the date and that the petitioner is underqualified for the post of grade 4. The respondents had the option of not placing the application again before the DLC once it was rejected on a interstate financial comparison, but having exercised the option to again place it, the law requires the application to be considered as per merit and the reasoning given, two reasonings given for rejection that the that the latest application was filed after 1 year is also be not tenable in as much as under compassionate law for appointment of compassionate, there can be only one application, and if the respondents desire so, they can place the application again before the DLC. But the other ground that the petitioner is underqualified for the post of grade 4 is unacceptable in law in as much as the petitioner has the qualification of higher secondary, and for a grade 4 post, the qualification is either matriculation or class 8 pass, as the case may be in different departments. As both the reasons are annexed in law, the rejection by the DLC meeting that it's 14 set aside, remanded back to be placed for the next available DLC of Morrigaon District.
Item 11.
District will be made Morrigaon.
Sorry,
District will be Morrigaon.
Morrigaon District. Yes, next one. Bhavani Chetri. SC Biswas. Yes, Mr. Biswas,
Yes, ma'am. Well, on,
please for filing and.
Official ground.
What is the matter?
well, earlier it was DLC has rejected the matter of that.
Compassionate
Yes,
appointment.
ma'am.
Where is the rejection?
Well, page 67.
67.
Minimum 3 years service was not there of my father.
Yes, go back. Heard Mr. S.C. Biswas, Land Counsel for the petitioner, also heard Mr. E. Saikia for the Deputy Commissioner Sonitpur and Mr. S.N.P. Chispi for the Secondary Education Department, Government of Assam. The second Government of Assam. The father of the petitioner, Ratna Bahadur Chetri, who was a grade 4 employee in the Karibil High School in the Sonitpur district, died in harness on 16/1/2016, and on his death, the petitioner submitted an application for compassionate appointment on. When did you submit?
One-
10/6/2016. The said application was placed before the DLC of Sonipur district in its meeting of 28/6/2017, but was rejected by providing that the deceased employee did not have the balance service of 3 years as required in clause 1 of the OM dated 1/6/2015. We take note that by the judgment dated so and so in WBC so and so, clause 1 of the OM dated 1/6/2015 had been set aside, meaning thereby that there is no requirement of a balance of 3 years of service. In view of the above, The rejection by the DLC by the order dated set aside, remanded back to the DLC of Sonipur for a fresh consideration of the application as per law. To be placed before the next available DLC.
12,
Yes, Mr. Singh.
My lord, here this case, my lord, the Arabic teacher, services dropped.
Arabic teacher,
Arabic teacher, his services are dropped at the time of provincialization. This,
provincialized of which year?
my lord, that was the last. My lord,
No, provincialized of 70 Act,
Yes, ma'am.
2011 Act or
17
17 Act, 70 Act, 77 Act.
Yes, ma'am. Lordship has earlier passed order, and they have approached earlier and that, in that case, my lord, direction was given to consider their case by speaking order. That has not, that has.
Where is the order?
My lord, earlier order, lordship will find, page, 31. Lordship-
According, we the met on a direction in the, to give a considered communication data. Yes, Mr. Chisti. I think we gave this order
Yes.
because there is a communication dated 17/8/2021 containing a proposal for provincializing the petitioner.
Yes.
So we said that pass a reason order on that proposal. It's a contempt petition actually.
My lord, the claim has been rejected by the order.
Okay, rejected by
This 37,
35.
saying that, this is the only.
Just a minute. Acha, FM and graduate.
Yes.
We issue notice, we'll hear.
Right.
Heard Mr. S. Sigdal and counsel for the petitioner. Mr. SMT Chisti learned counsel appear for secondary education department
124.
and Mr. P. Saikia for Deputy Commissioner Borpeta. Notice 6 weeks, extra copies, 3 days, list after 6 weeks.
item 14,
Matter pertains to the year of 1992, when an amount of fees 10,34,000 as per plan adopted by the WPP and DC department.
Sorry,
Lordship,
please repeat what you are saying.
issue is, this is the fourth time the petitioner.
No, doesn't matter. What legal right of the petitioner had been violated?
Lordship. If your lordship, get precise, then, last order was if your lordship.
Please come directly. Which legal right of the petitioner had been violated so that we can start thinking in terms of your matter?
Lordship, in the year 1991-1992, the WPT and DC department allotted an amount of rupees 10,34,000 as financial assistance for educational development and upliftment of the ST community people of Karimganj district. And along with that, 94 numbers of posts of private stipendiary teachers were also created for fulfilling.
Created,
Yes, for that purpose. Now.
created for appointing only scheduled tribe.
Yes,
Where is that creation order?
a list was
No,
submitted.
where is the order where 900 posts were created for scheduled tribe candidates?
94 numbers of posts.
Forget about the number. Where is it? Which page?
Annexed to one, your lordship.
Page number
Page number 27, 28.
27, 28. No, this is some selection list,
Yes,
list of
sir, that
94 eligible scheduled caste candidates.
Yes, lordship.
It's not a creation of post.
List
so-
was submitted to the, those list was submitted to the, District Elementary Education Officer, Karimganj. Thereafter, if your lordship kindly peruse the annexure 1, then, petitioners, who are, appearing before this honorable court, through their association, a list was a list of 94 teachers were created, selected.
Madam Dasgupta, just a minute. Your prayer number 1, we cannot accept. To comply with the direction of the court, there is second repetition is not maintainable.
No, this.
Number, you have to have come in contempt. Second, is not maintainable. Provide the petitioner association with the list of person. This is not a RTI code.
Peruse annexed chart and then your lordship.
We may peruse, may not peruse, but this is a authority of the under the RTI, not a 226 petition. Prayer number 3, to appoint the petitioner who is selected of the 84 numbers of deprived beneficiaries, appoint against the backlog vacant post kept pending as per the order dated.
Lordship may kindly peruse annexed chart and then your.
Your Dasgupta, S Dasgupta, notice 6 weeks. Copies to be.
So lordship peruses the annexed chart and then it was your lordship's order.
Maybe, doesn't matter.
To provide a list.
That will not make the order more stronger because it is the same judge. We issue notice.
Yeah.
There is no interim prayer also. Secondary Education Department. Anybody else? No, elementary education. Who appears for Director Welfare of Plain Tribes and Backward Classes?
Lordship, one order was passed.
Please, madam.
R.
You appear for
WPT.
Director of Welfare of Plain Tribes.
R.
Where is he? Or finance, Sonia Finance. Thora, did you notice 6 weeks, extra copies 3 days? This after 6 weeks.
Item 15,
The request. made on- Yes, Mr. Seika, what is this matter?
Petitioner at page 14 was.
Provincialization.
For employee on 30/3/2011. And he joined in service and is working as a grade 4 employee till now. And he is the only Shogida, he only grade 4 employee in the college. So we moved an application.
Yes, Mr. Chisti, Mr. Kaushik, you appear? You appear? Higher education. So I think having been appointed in the year
2011.
11,
Yes, sir.
it was a ventures college.
The answer college.
It was a venture college. He is claiming a right of provincialization. Keep the post vacant, don't fill it up. The post of peon grade 4 in Sonari Commerce College, Soraido, be kept vacant until further orders. Be not filled up until further orders. Notice 6 weeks back in higher education irrigator DD college con registered post.
item 16,
16 is appearing. He does. None appears for the petitioner. List again.
item 17,
Compassionate appointment.
Yes,
DLC,
rejected, lordship.
which page?
Lordship. Yes, 35, DLC issued the letter, lordship. Letter.
35.
Yes, 35, lordship.
Late submission.
Yes, lordship.
When did the man die? On which date submitted?
Lordship, 26/11/2001, lordship.
26/11/2001, he died.
Yes, lordship.
And application,
26/2004, lordship.
why 3 years delay?
At that time, he was underqualified.
Yes, what to do? Okay, we issue notice. They have to hear them also. Heard Mr. Ann Hussain and counsel for the petitioner also heard. Yes, for elementary, secondary or elementary?
Even
element.
elementary.
Then respondent number 1.
Secondary, another.
That's why I'm asking which one.
So
Petitioner to incorporate necessary correction in the course title, showing the area of respondents.
Item 18,
Item 18.
That petitioner is paying for.
Change of examination center. Where is Mr. PJ Cooper? Just try to find out whether he is there. Is he around? No.
I will call him not that two not.
19,
Kindly, so for the matter, for the time being.
20,
Sorry.
Perhaps the lordship may not like to take up this matter.
This item 20,
My lord, AG will be appealing this. 19.
unless before any other code it out.
19 to. Kuntu item?
20 without me.
None.
19 is time me.
19, my lord.
Oh, 19 not likha without me. It will come up before some other court. Yes, item 20.
Item 20,
Realistically, district scrutiny committee recommended the service of the petitioner. But
Provincialization.
Yes, but the director rejected the claim of.
Page number?
petitioner. Page number, that is page, starts from page 50.
Now, where is the reason why the director rejected?
Because there's a direction to consider the provision of the section 311, 312 and RDI. Lordship, we kindly come to page 48, but this is not compliant.
No. Why the director rejected?
The ground is that there is no provision for granting any additional post.
So where is it? Which page?
In page 52, in view of above, as per minutes of the SLC,
In view of the above.
page 52, Lordship. The order, Lordship, in view of above, as per minutes of the SLC dated 24/2005, as well as inquiry report submitted by inquiry officer, it reveals that maximum limitation of staff ME school is 5. Accordingly, the SLC and joint committee recommended 4 number. School for provincialization as tutor as per 17, wherein science teacher.
No, Amina Khatun, she is a science teacher.
Not science teacher, Lordship. He is-
Science teacher could not be done because
he is not having quality,
there is not there in this code.
Lordship. But
So
here,
now how many teachers are provincialized?
4
4 are provincialized.
are provincialized.
Science is not
Science is
provincialized.
not provincialized.
So Amina will be the
The additional teacher, Lordship.
6th one.
6th one.
If we include the science, she will be the 6th one.
6th one, Lordship. But the act provides, Lordship,
Act which section?
section 311 and 312.
Page number,
Yes,
page number in this book.
Lordship, I'm sorry, Lord. Lordship, page.
You are governed by the 17 Act.
100, yes, 111, Lordship.
100.
111, and provided, the second provided.
There shall be minimum 3 teachers or tutor, at least one for provided for additional post
Yes, provided that for additional post.
according to the norms and standards
Of the-
stipulated in the schedule under
Section 19
section 19.
and 25.
This one possibly number of students, I
Yes,
think.
because in the school. there
Ah,
are 200
how many students are there?
270.
And 270 is equivalent to
6 Lordship,
Six.
35 for each. class.
which page is that one? RT?
RTI, RTI Lordship is provided in the schedule, Lordship. Lordship will come to.
Page number. Your relevant page, you could have marked the page number and come to the court. Instead of taking the time here.
I have put that.
Forget about quota. We don't go by
In
the.
the schedule of the RTI, it is provided, Lordship.
RTI is possibly not in this book.
Yes, sir. RTI, Lordship. Here it is, at least one teacher for every 35.
Just a minute. As per,
Schedule of section 19 and 20.
no, as per, just a minute, as per. Schedule under section 19. Where is the schedule?
Schedule, Lordship, I am holding the
Hmm.
RTI, Lordship. আছে পুৰণাখন নাই ন, নতুন book. The new book it is not there also.
What is the number of students?
Number of students is 217 minimum. And they have also admitted
No, just a minute, 217.
17 Lordship. Act provides at least one teacher for every 35 children. So at least 6 teachers.
No, no. Come to serial number 1,
Of the Act Lordship.
huh, 61 to 93 teachers.
So this is for class LP school. Lord.
LP, where is Amy?
The B for 6 class to 8 class.
For
B.
6 class, at least
At
one
least-
teacher per class,
So that there
so
should
that
be
there shall be at least so and so, at least one teacher for every 35 students
yes, that
is
good, Lord.
above 100 full-time head teacher. So 270 will be,
More than if 35 is the minimum requirement. So
yes,
35
how do you interpret the schedule? How do you interpret the schedule to the Right to Information Act?
At least one teacher per class, so that there can be at least one teacher each for science and mathematics, social.
That we, no, we have read it. How do you interpret it? He is saying,
My lord.
if you look at that clause 2, at least one teacher for every 35. So if the school has 105 teachers, 3 teachers, 140, 4 teachers, 175, 5 teachers, 210, 6 teachers, and so on. That is his interpretation.
Yes.
Do you also interpret the same way? Then how do you interpret?
Can appoint another additional teacher.
There's no additional. Look at the proviso. For addition, it shall be considered in accordance with schedule under the right to inform, right to free education. That is the schedule before you.
My lord.
Schedule says one teacher each for science,
35.
social science, language.
Right.
Thereafter, one teacher for every 35 students. Yes, Mr. Chisti,
in base.
how do you interpret this one? Do you interpret in the same way Mr. Dekar tries to interpret? Read both together. 311 proviso.
Provided that for additional post, it shall be considered in accordance with the norm and standards stipulated in the schedule under section 19 and
Ah.
25.
So now come to the schedule under 90.
Schedule under 19.
First provision is same.
Same.
One teacher for science, social studies, language.
Yes.
Then at least one teacher for every 35.
Every 35 students.
So this school has 270.
Page 51 admitted.
So every 35, if you have one student, for 175, there will be 5 teachers. 210, 6. 245, 7. So this school needs 7 teachers then. We asked, quote the provision, ask the director to interpret it, send it back. Heard Mr. A. Dekala and counsel for the petitioner also heard. Your name or Mr. Chisti's name? MS N. Phukan for the Elementary Education Department, Authority and Elementary Education Department, and Mr. P. Saikia for Deputy Commissioner Nagaon. The petitioner Amina Khatun is a teacher in the Borpani ME School in the Nagaon district, having been appointed on 14/11/2004, when the school was in its venture stage. When the teachers of the school were provincialized under the Act of 2017, the claim of the petitioner to be provincialized was left out. And in the circumstance instituted WBC 5504 2022, wherein an order dated 31/8/2022 was passed. What order?
Yes.
Page
Page
number
49, Lord.
49.
While considering the representation.
And an order was ordered date 3/8/2022 was passed, requiring the respondent number 2 being the Director of Secondary Education, Elementary Education Assam, to consider the representation dated 8/2/2021 claiming for provincialization. Consequent thereof, the impugned order dated 31/5/2023 had been passed by the Director. And the conclusion thereof is as extracted, page 52. The Director was to review as the science teacher of the school could not be provincialized because the name did not appear in the Dice Code. Therefore, 4 other teachers having been appointed, it has to be construed that under the law, 5 teachers have already been appointed in respect of Borpani ME School. Accordingly, the Director was reviewed that the claim of the petitioner would be against the 6th post, which under the law would be disentitled, which under the provisions of the Act of 2017 would be disentitled. Provincialization of teachers in respect of ME School is provided under section 3 bracket
11.
straight away 11 or 3(1)(11) of the Act of 2017, which is as extracted. The plain reading of section 3(1)(11) would be that 3 teachers or tutors of whom at least 1 teacher would be for science and mathematics, social studies and languages would mandatorily have to be appointed. For additional posts, the norms and standards provided in the schedule under section 19 and 25 of the Right of Children to Free and Compulsory Education Act 2009 would be applicable. In short, 2009 Act. The schedule 1, the relevant schedule, the schedule under section 19 and 25 under the Act of 2009 in respect of ME School is extracted as below. A reading of the extracted provision of the schedule of the Act of 2009 makes it discernible that the schedule also provides for 1 teacher each for science and mathematics, social studies and languages. Subclause 2 of schedule of serial number 1B of the schedule provides for at least 1 teacher for every 35 children. If under the proviso to section 3(1)(11) of the Act of 2017, the schedule would govern as regards appointment, as regards provincialization of additional teachers, serial 1B2 of the schedule to the RTI Act of 2009 would also be a relevant provision, which provides for one teacher for 35, every 35 students. Mr. A. Dekar, Learned Counsel for Petitioner, states that in the Borpani ME school, the total number of students is 270. Which means that up to 175 teachers as per serial 1B of the schedule, the requirement would be 5 teachers, and up to 210 students, it would be 6 teachers, and thereafter up to 245 students, it will be 7 teachers. If the information provided that the school has 270 teachers is correct, comma, a plain reading of the provision of serial 1B of schedule to the Act of 2009, read with the proviso to section 3(1)(11) of the Act of 2017, makes it discernible that the school in question would be entitled to 7 teachers. In view of the above, the rejection of the claim of petition for provincialization by the order dated so and so of the director appears to be a rejection without taking note of the relevant provisions of the proviso to section 3(1)(11), read with schedule serial number 1B bracket 2 of the schedule to the RTI Act 2009. Accordingly, matter remanded back to the director for a fresh consideration of the aforesaid provisions, and also to arrive at a factual determination as to what would be the number of students of the Binapani ME school. Upon doing the needful, a reasoned order on the claim petition of provincialization be passed, which to be done within a period of 2 months from the date of receipt of the certified copy of the order.
Page 51, they have admitted. Director admitted.
We have passed our order. Won't do. Oh, no, I need. Sorry,
Item number 19, it was my fault, it was not that matter.
some other matter. Did the petitioner
I have it.
inform the petitioner, we'll
I
take it up. We'll take it up in the end of the list again.
I have it.
Second call, yes. 21.
21,
Yes, Mr. Modular,
This matter is about compassionate appointment.
compassionate DLC,
It was not placed in the DLC.
was it placed?
Not placed.
Not placed. The same order, give the particulars, date of death, date of application, district, and all.
22,
Yes, Mr. Count,
This case, my lord, the SLC rejected, my lord. Earlier,
SLC rejected.
yes, my lord.
Where is DLC?
DLC's recommendation is at page, my lord, 61,
61,
and 63 is the operative part, my lord.
63. Konindra,
Konindra Rao.
Konindra Rabha. And this is by DLC.
Then the SLC rejected,
Where is the SLC?
SLC is at page 68.
Why is it placed before the SLC? There is no requirement.
There was-
DLC was right. DLC says that to call for the information whether vacancy available in other departments. So you should have waited and again placed it before the DLC. Why did it go to the SLC? SLC, it will go only when there is a recommendation. There is no recommendation.
SLC, take up the.
Where is the SLC?
Case number
Case 68.
68.
Should we show cause the SLC? No, see, SLC writes. DC Bogagin to show cause as to why he was selected, although he did not meet the selection criteria. Should we show cause the SLC now? Why you are passing this order? What wrong did the DLC do? DLC went by the court direction and by the provision of the OM.
Is +7.
Huh.
Perhaps +7.
Decided to consider for the post of subject to fulfill of departmental norms, as you know it, that there are grade 4. So they have tentatively accepted it, provided there is vacancy. Now it is for the DLC to find out whether there is vacancy or not. Why should the SLC reject it?
Also rejected, madam, saying
DLC had recommended, they were vacancies.
DLC is not recommended.
Recommended, madam.
No.
Last slide, DLC directed DO Bongaigaon to submit a proposal of the recommended applicant. At page 63. Page 63, madam.
But see, before that, Mr. Count decided to consider the application, okay?
Yes, madam.
Then subject to fulfill of departmental norms,
Yes, madam.
as in ODO, there are available grade 4 vacancies.
Yes, madam.
Acha, in the DO, there are available
Yes,
vacancies.
madam.
But this you cannot do. The elementary education department must agree with it. Read the OM.
They have agreed, my lord, at page 65, my lord. There is a forwarding of to the
Who had agreed?
district elementary education officer, page 65.
Okay, they have agreed.
They have agreed and sent a proposal to the director of elementary.
Submitted a list of who are recommended. No confusion.
When they have to send to SLC on the director.
Then why did the SLC reject it? Not only reject, also show cause.
Because madam, that candidate, madam, he is 7%.
After scrutiny, Department of School Education did not find him eligible for appointment. In only, okay, your qualification is class 8,
7.
class,
7. Not
you are not qualified.
Issue, my lord, is that as per the rules is silent, my lord. The rules, my lord, the Assam Elementary Education Provincial Service and Conduct Rules.
No, every department has a minimum qualification. The rules may be silent, may be having some other supplementary rules.
This rules, my lord, this 1981. rules-
So, Mr. Khan, is it your submission that one class, one pass will also be appointed because the rules are silent?
Because I am-
Same argument.
Yes, that is true, madam. But in that 81 rules, the qualification for.
But you
minimum
cannot, qualification you cannot bulldoze even in.
Qualification for teacher is matriculate, as per the 81 rule.
Okay, we issue notice, heard Mr. S. Count. But difficult for you. I was thinking whether I can delete today itself. Peace idea for Chief Secretary, Deputy Commissioner,
1, 2, and madam, 7.
Deputy Commissioner Bongaigaon. Isulia Finance. And Fukan Elementary Education Department. Notice 6 weeks, extra copies, 3 days. But qualification will be difficult to overcome, whatever you say.
23.
There,
Try to acquire a qualification in the meantime. We'll send it back.
Lordship petitioner, headmaster and he is teaching language subject. But in the year 2018, his name was not recommended by the district scrutiny committee, saying that due to availability of required enrollment. His name was not.
LP school or ME school?
ME school, my
Where is it? Which page?
that is, my lord, page 36.
Page 36.
36, my lord. Petitioner is,
Antiram Bormon,
he is recommended.
language is
Language.
recommended.
Yes, my lord.
Vacant,
7, the
Mozid language. Mozid is
Language.
also language.
Shantiram was recommended, my lord.
Huh.
Moses not recommended serial 7, my lord, details of teachers who are.
Not eligible
Yes,
due to non-availability of required enrollment.
En-
Right there. Because you have to go, Mr. You have to go for the additional post.
my lord. But
Because you are neither science nor social science. You are only language.
Lang-
Language, one man is already there.
they are, my lord, but Shantiram Burma during process died.
Then the post will fall vacant.
then-
2000, it will be recruited under the 2018 Act.
He died in the year 2020. Provincialization was done 2021.
Okay,
In
before,
between, the name of the petitioner also recommended, that is page, my lord, page 59. After his death, petitioner approached to the
Santiram, was he provincialized?
wrongly provincialized.
Wrongly or rightly, he was provincialized. His family is getting some pension.
No, because he could not join also. Before provincial, he died in 2000.
If he is getting pension, we don't want to disturb that family.
Not, no, nothing. In thereafter, my lord, in his.
Not get anything.
Parents will not get anything because provincialization, if he has not, he has died, he could not join.
He will not get anything. Then I think this man will be entitled.
Then
Mozid.
he died, my lord, 6/1/2020, and provincialized was done.
The respondents in the elementary education department, Mr. Just a
The
minute,
director has issued the interim order saying that
just a minute. We have seen it. The responding elementary education department to provide the information as to whether the services of Santiram Bormon was formally provincialized pursuant to the recommendation of the DSC available at page 36. If Santiram Bormon was not provincialized, whether it would be construed that no teacher for language was provincialized in respect of Paschim Gaikwar ME school. And if yes, why the petitioner being the second other language teacher of the school should not be processed for provincialization? List after vacation.
I'm all.
This
24,
information, please give us. Yes, Mr. Hawk.
My lord, petitioner passed MA in political science. But his final mark sheet and the certificate has not issued by the respondent university.
For which exam he passed?
My MA in political science,
Wait, they don't give fees over.
my lord, in every semester mark sheet is there. But final mark sheet has not been given,
Right?
and certificate has not been given. I have filed representation.
From Kumar Bhaskar Verma, Sanskrit and Ancient Studies, University,
Nalbari.
Nalbari. Yes, any idea why certificates are not given? From which school he studied?
That university is, yes,
University with Kumar Bhaskar.
Kumar Bhaskar, in MA in political science.
No, MA,
My-
okay, MA. Mhm. Who appears for Kumar Bhaskar? Do you have any standing counsel?
I don't think so.
Then you serve dusty on the university and come.
Can it be, I have filed a two representation, annex 9 and 10.
Dispose it off.
My lord, can it be?
Okay. Heard Mr. N. Hockland, counsel for the petitioner, also heard. Mr. Yeah, Pavitra, Learning Counsel for the Higher Education Department, Government of Assam. Considering the nature of the order proposed to be passed, notice for the present not required to be issued to the respondents number 3 and 4 being the authorities under the Kumar Bhaskar Burma Sanskrit and Asian Studies University, Nalbari. The petitioner, who is a student of political science in the respondent Kumar Bhaskar University, full stop. She passed out her first and second semester, but in respect of the third semester, as she did not have adequate attendance, she was not allowed to appear. But in the meantime, she was allowed to appear through the online method in respect of fourth semester, and she had passed the fourth semester. In paragraph 8 of the writ petition, it is stated that the university authorities advised the petitioner to appear in her third semester examination as arrear, and accordingly was issued an admit card for the year 2021. The petitioner appeared in her third semester examination and passed the same. And on the dates when she appeared in the examination, she had taken leave from the departmental authorities in the elementary education department, under which she was serving as an assistant teacher. But the grievance of the petitioner is that although a grade sheet of third semester of the petitioner dated 26/5/2022 was provided, but she has not been issued the final certificate of passing the MA examination in political science. Being agreed to, representations had been submitted by the petitioner before the registrar of the respondent university, dated 4/1/2023 and 31/3/2023. The grievance raised is that neither the certificate had been issued nor any reason order had been passed on the representation of the aforesaid representations of the petitioner. In the circumstance, instead of issuing notice, we deem it appropriate that the ends of justice should be met on a direction being issued to the registrar of the Kumar Romukomuge University to consider the two representations of the petitioner dated 4/1/2023 and 31/3/2023 and pass a reasoned order thereon. If the authorities are of the view that the petitioner is entitled to the certificate, the same be accordingly issued. And if the petitioner is not entitled to the certificate for any reason, the reason thereof be stated and the petitioner be informed accordingly.
Representation before the controller of examination, not registered.
Controller. Although the representations are addressed to the controller, the same be given a consideration by the registrar.
25.
25.
May I please? Also in this matter, petitioner has been degraded from the post of head teacher to assistant teacher.
Demoted.
Degraded, Lordship. Impugn order at page 17, Lordship.
17.
Without issuing any notice or focus.
I heard Mr. State. I heard Mr. MK Hussain, Learned Counsel for the petition, also heard Mr. Ganesh Pegu, Learned Counsel for the Elementary Education Department, and the petitioner, where is the order allowing you to be headmaster?
Annex A, page 12, Lordship.
The petitioner was appointed as the appointed or allowed?
It can be presumed promoted, but this
Was allowed to be the headmaster of Noor Nagar LP School in the Nagaon district, as per the order of the Block Elementary Education Officer dated 28/8/2003. By the impugned order also of the Block Elementary Education Officer, the petitioner is reverted back to an assistant teacher, and in his place, another teacher of the school, namely Rahimuddin Ahmed, was allowed to be the head teacher in charge. The order dated 9/10/2023 reflects that it was done in the public interest and as per certain public allegation against the petitioner Muhammad Sharif Ahmed. The order does not, order appears to be having the effect of adverse civil consequence upon the petitioner, and it does not reflect of any required procedure of law having been undertaken before the order of demotion or the order of relegating the petitioner down from being allowed to be the headmaster of school was followed. In view of the primary case made out, the order dated 9/10/23 shall remain stayed until further orders. Notice 6 weeks, extra copy 3 days, steps registered post 3 days.
private respondent.
26.
Bigger part is the compensatory appointment. DLC rejected.
DLC, which page?
Page 19.
Thank you. Anamika, no, Samin, where is Samin? Samin.
Page 19 first one, in the
Top of the list.
top of the list.
DLC,
DLC.
go back. I heard Mr. S. Historical Council for the petitioner also heard Mr. Ganesh Pegu for the authorities and the elementary education department, Mr. P. Saikia for the deputy commissioner Kamburg. The father of the petitioner, Prasanna Ramdas, was the headmaster of Khuponi Kusi LP School in the Kamrup district, died in harness on 21/5/1996. And on his death, the petitioner submitted an application for compassion appointment on 29/8/1997. The said application was considered by the DLC of Kamrup district in its meeting of 31/12/2021, but rejected by providing that the application was made after the petitioner had not applied within the time stipulated for the purpose. It is stated that the stipulated time as per the respondent authority is 1 year from the date of death. It is no longer a res judicata that the requirement of the application to be filed within 1 year is a directory provision and not a mandatory provision, and without considering the applications on merit, it ought not to be rejected merely on a technical ground of having not been filed within 1 year. In view of the above, rejection by the DLC that is set aside, remanded back to the DLC to be placed before the next available DLC for a fresh consideration, strictly as per law and entitlement.
I'm deeply obliged.
27.
For other reasons, it can be rejected. Only thing, given the wrong reason.
Obliged.
Yes, Mr. Das.
In this case, my lord, pursuant to lordship order, my lord. Here, my lord, direction was for district level scrutiny hearing, my lord. Scrutiny committee's hearing, my lord, and that is rejected, my lord. Subsequently, my lord. A rejection order is, my lord, kindly peruse your lordship. Yes, 104.
Notice heard Mr. H. Das, man counsel for the petitioner. Mr. B. Kosik for Elementary Education Department. Steps on respondent number 678 registered post 3 days, list after 6 weeks.
9 also, private.
9, okay, 9.
Orders navigating item 28.
The matter in which I was appointed the court commissioner.
That matter.
I visited the place, I submit my report at 2 p.m.
Sorry,
At 2 o'clock, I'll submit my report.
2 o'clock.
If some,
Is there any urgency?
my business has been,
Yes, my lord, had there been business certainty, but there was no business on that day.
No, we go by the report.
My lord, yes.
The report says yes, yes, no, no. No, can you wait after vacation or it has to be taken up today? Hmm,
Possible tomorrow, they
almost we have no time. So can you wait till after vacation? Immediately on the reopening? We'll give a fixed date. Mr. S.T. Kyal, learned the council was required by the order dated 6/10/2023 to submit a report upon the inquiry, states that a report is ready and it will be filed in course of the day. List on immediately on the open.
7th November.
For consideration of the report.
Much.
Item 30 for admission.
Mr. Kyal, did you get your dues for the inquiry? Yes, madam.
Your lordship, the matter here pertains to provincialization of the service of the petitioner in the third post of July.
By the order, you be allowed to serve Dusty on respondent three affidavit. You serve Dusty. We can accept the notice. By the order dated 11/9/2023, the petitioner was allowed to serve Dusty on the respondent number 3 and accordingly an affidavit has been dated. Where is the Dusty affidavit? It's not here.
Page 59, 60.
I wait for some time.
No, first let us see number 3. No, 3 is not the Dusty affidavit. Because the Dusty order is 11/9 and this affidavit is 15/5.
No, lordship, the dusty order is of 3/3, lordship, 3/3/2022.
Okay,
Page
I
59.
understood. Huh?
Otherwise.
By the order dated 3/3/2022, the petitioner was allowed to effect justice service on the respondent number 3 and accordingly an affidavit dated 15/5/2023 had been filed, which contains a copy of the, where is the,
63, lordship, page 63 is the
Huh?
acknowledgement. Page 63 is the acknowledgement.
no, then affidavit is different affidavit, not this one. 23/5/2022. Huh? And accordingly, an affidavit dated 23/5/2022 had been filed, which contains the no, please find out
Lordship,
some mix up. Call again.
33.
Find out your Dusty affidavit page number. Yes,
I need some, I have received the instruction, but instruction is not adequate, lordship. So I have. asked-
don't know the premise
Immediately after application.
for the
Secondary.
required information and affidavit
Yes.
responses.
34.
34 years.
November.
Sorry,
Infrastructure, because the order.
infrastructure, they will say. How can the respondent say infrastructure? Is it infrastructure?
Sure.
Your name?
See that.
Do you appear in the matter?
Yes, it's there.
Your name is there?
Yes, your lordship.
MST task when counsel for a petitioner states that this petition was instituted for what purpose?
As for the, a in charge has been replaced by another.
In as much as one in charge headmaster had been replaced by another in charge headmaster. Regularly appointed. Why infractions?
Lordship, the impugn order has been recalled.
Have been recalled. It is stated that the impugn order dated so and so had been recalled in the meantime. 28/9/2022 have been recalled in the meantime and therefore no further adjudication required. Writ petition closed, liberty granted to approach again if so advised. Mr. AMS Mojumdar appears for response 5, Mr. Chitti for
35.
department.
This case, lordship, for the lordship wanted some instruction to be placed. Will require some more time, my lord. As per the order dated 6/10/2023, Lordship directed us to place the status report. Status. Consideration. For consideration of the appointment, Lordship. My lord, kindly peruse the 29/8/23 order, Lordship. Lordship's order. This honorable court's order. And 6/10/2023.
Title suit, why record of title suit?
Actually, Lordship, earlier kindly peruse the order dated 29/8/2023.
I heard Mr. K. A. Mojumdar, land counsel for the petitioner. Also heard Mr. B. Kaushik, land counsel for the
Elementary.
elementary education, Department of School Education,
Department.
School Education, Government of Assam. By this petition, the petitioner was under process for an appointment as what?
Assistant teacher. Lordship.
Assistant teacher in the, which
LP
school?
of Hailakandi.
Huh? In the,
School of Hailakandi district.
in
LP.
in a LP school in the Hailakandi district. But before the appointment order can be issued in favor of the petitioner, another person, Azmat Ali Chaudhary,
Lordship.
who was otherwise not entitled for an appointment, had been substituted in place of the petitioner and appointed. By our various orders, we required by our various orders from 14/11/2022, very orders of 14/11/22, 21/6/2023, 4/8/2023,
29/8/20.
9/8/2023, 17/8/2023, 24/8/2023, we require the departmental authorities to provide the information as to why the other person was substituted in place of the petitioner for the purpose of appointment. We had also noted the matter in detail in our earlier order of 29/8/2023 and 6/10/2023, wherein an observation was made that it had already been prima facie noticed that the writ petitioner was illegally taken out of the process of being appointed, and another person, Azmat Ali Chaudhary, was not entitled to an appointment, had been substituted and accordingly appointed. Today also, when the matter came up, no information, credible information is available as to why Azmat Ali Chaudhary had been appointed in place of the petitioner who was processed for the purpose. Azmat Ali is a respondent.
No, Lordship. No.
The writ petitioners to implead Azmat Ali Chaudhary.
Lordship, as per my inspection, Lordship, he died in normal birth. And apart from that, their affidavit, they have admitted in paragraph 4, Lordship, of page 162, that below me some persons were appointed.
Then it will be complicated for you.
Lordship. If necessary, Lordship.
No, Mr. Mojumdar. If he had died, it will be complicated. We are thinking of staying his appointment, bring him and decide the matter.
Lordship.
But if he died, we cannot, just a minute.
Sorry, Lordship.
If he had died, we cannot determine the legality of his appointment. That means in this post, somebody was appointed and later on post fell vacant because of died. Now it will be filled up by the general process.
I'm not against that post, Lordship. In their affidavit, they have stated, the answering deponent begs to state that the writ petitioner so-and-so was one of the candidates selected for a.
In view of the above,
And
the appropriate information be provided to the court as to why the writ petitioner had been left out of the process of appointment. So that consideration can be given on the next returnable date, list on so and so. If the information is not made available, the Director of Elementary Education to remain personally represented before the court along with the complete records.
Item 36.
Fixed date. Ask him to give the information.
Yes, yes.
Hmm.
22, huh?
Declare a degree invalid.
Yeah, just a minute. We have already decided this issue in the meantime. So whom do you appear, Mr. Mukhtar?
And if there is no respect number 6, my lord.
You are the beneficiary.
Not a beneficiary, I am also one of the teachers, but we all are contending for the headmaster, my lord.
Hmm. But this degree has to be recognized. But you can place him under suspension. That you can do. You are subjected to be a disciplinary proceeding and being placed under suspension, but you cannot de-recognize his degree.
Yes.
The law is already settled.
Your lordship has-
Oh. So only the university can recall a degree given, not by any other authority.
Authority, my lord.
Ah.
We cannot invalidate.
You cannot invalid. But admittedly, it may be a misconduct as per you.
I did.
Then you proceed it as a misconduct, whatever action you want to take. He'll defend it.
Lordship.
Heard Mr. Yes, Bothakur and
Same is the case with the other person, so your lordship, his degree, your lordship, BA degree is also your lordship without permission. your lordship.
That is not under challenge in this case, my lord.
No, that is not under.
That it doesn't matter.
Lordship.
Challenge, unchallenged doesn't matter. Also heard Mr. B. Kaushik, Learned Counsel for the respondents in the secondary education department, and Mr. S. Mukhtar, Learned Counsel for respondent number 4, Nurul Amin Ahmed.
Yes.
How many petitioners?
Three, your lordship.
Three.
Three.
All the three petitioners hearing had obtained their degrees in arts. What degree, Mr.?
MA degree. your lordship.
Their MA degree respectively from the Chhatrapati Sahuji Maharaj University, Kanpur and K.K. Hendrick State Open University. In the years,
That is your lordship.
in the years so and so.
I.
The three petitioners along with the respondent are all vying to be the headmaster or principal.
Principal.
Principal of same college, same school or different school?
Same school.
Name of the school?
It is your lordship, RBP Higher Secondary School.
Of
South-
the RDP Higher Secondary School, South Salmara, where one of the required qualification is MA degree.
But in my case, my PhD is only from my this thing, PhD degree. My MA,
We are not on facts.
but because your lordship has already MA.
MA degree. Where is the impugn order dated?
Lordship, that is at page 52.
Hmm,
Page
27/1/52.
52.
By the impugn order dated 27/1/2023 of the Director of Secondary Education, Assam, the candidature of the three petitioners, namely G. Rahman, first one,
Ghazi Rahman.
Ghazi,
Ghazi.
namely Ghazi Rahman, Zakir Hussain Bepari and Zahirul Islam Mullah were rejected in as much as the MA degree obtained by them was found unacceptable to the director in as much as the said degrees were obtained without prior permission from the appointing authority. And therefore, it was a violation of clause of Rule 13 of the Assam Civil Services Conduct Rules 1965. On the other hand, the petitioners allege that the BA degree of the respondent number 4, Nurul Amin, was also obtained in the same manner of not having taken permission from the appointing authority. Full stop. The order dated 27/1/2023 is assailed in this writ petition, inasmuch as the degrees of the three writ petitioners, as well as that of the MA degree of the three writ petitioners, as well as the BA degree of the respondent number 4, were all obtained, were all awarded in a valid and legitimate manner by the respective universities from which they were obtained. And therefore, the Director of Secondary Education Assam, in respect of the petitioners, did not have the jurisdiction and authority to invalid the degrees for the purpose of considering them in the process of selection of the principal of the college, of the school. The reasoning given by the director that having not obtained prior permission from the appointing authority, Rule 13 of the Assam Civil Services Conduct Rules 1965 was violated, would be unacceptable in law in view of the pronouncement of this court rendered dated 28/9/2023, rendered in IA Civil 2615/2023, wherein the consideration was given to the question as to whether if a degree is obtained by an person who is in service of the government of Assam without obtaining prior permission by authority would be a valid or an invalid authority. By the judgment and order dated 26/9/2023, it will go to the in Mosumi Soharia versus so and so. In Mosumi Soharia Supra, it had been held that if a degree had been obtained without obtaining prior permission from the appointing authority, the same would be a misconduct under Rule 13 of the Assam Civil Services Conduct Rules 1965. And it being a misconduct, the relevant provision of law applicable would be proceeding against such candidates under the Assam Services Discipline and Appeal Rules 1964. But the same by itself cannot invalid the otherwise valid degree obtained from the respective universities. And further, that a degree obtained from a university is governed by Section 22 of the UGC Act 1957. As the MA degrees of the three writ petitioners were also invalidated by the director by the imperial order dated 27/1/2023. We are of the view that under the law, the same would be an unauthorized act, and accordingly, the invalidation of the MA degree of the petitioner by the imperial order dated 27/1/2023 is set aside, and the matter is remanded back to the director to process the respective claims of the petitioner as well as the respondent number 4 as per law. But however, as already observed, setting aside the order dated 27/1/2023 shall not be a legal bar on the part of the authorities if they intend to proceed against the petitioners as per law as indicated. The bar is not there.
One more aspect, Your Lordship, we have put to challenge Your Lordship, order dated at running page 74, Your Lordship.
Another order.
Your Lordship, whereby Your Lordship, the respondent, who is a private respondent is allowed to take charge of the by the inspector. So going beyond the order of the director.
Being the senior most teacher, this
But
is
that
arranged,
is-
my lord.
Having set aside the order dated 27/1/2023, the director to also look into the validity of the order dated
Yes, ma'am. That may-
28/1.
28/1/2023, by which the respondent number 4 was allowed to be the in charge principal of the
Academic sense.
academic in charge of the school,
Academic matter.
and whether in view of setting aside the order dated 27-1, the respondent 4 would still be eligible to be the in charge. The revision order regarding the in charge be passed within a period of 15 days from the author receives certified copy order. And as regards processing the claim of the petitioners on the basis of their respective MA degrees be done as per law. Or any time limit for that. No.
Affidavit in opposition. But I have obtained instruction from the deputy commissioner. Deputy commissioner said that there is no separate list of rejection ground cited. Sorry. There are no any separate ground cited matter in this pilot in 2009 matter. Highly affidavit. You pass an order.
The deputy commissioner to file the affidavit as required by the order of 30/8/2023. Definitely by the next returnable date based on so and so.
Item 38.
Here we have challenged the evaluation order dated 13/8/23 and the
Any affidavit file? You want to file it?
affidavit not filed.
Mr. SMT Chisti, learn counsel for the secondary education department, is for 4 weeks time to file affidavit. Just apply this.
39.
Yes,
In this case,
39.
readings are complete, my lord. It may come up for admission. Readings are complete, my lord. This is for appointment of arbitrator.
Appointment of arbitrator,
Yes.
who appears for the PWD?
For PWP, sir, Mr. Nar. Mr. Nar.
Only for appointment of arbitrator.
Yes, only for the appointment.
We can do it today only. There is no adjudication required.
No,
Are they disputing
no, they are
that
not.
a arbitrator should not be appointed?
No, my lord, only one
No.
thing, they are not disputing like that. Only one thing is that, my lord, the appointing authority, instead of appointing the arbitrator, they demanded fees of 35,000.
Sorry,
The appointing authority in chiefness, my lord, which is provided in the agreement. Where they are, instead of appointing the arbitrator, they demanded fees, my lord,
who?
35,000.
Who?
The appointing authority. my lord. And the agreement does not say for payment of anything, because we have to
Where is the arbitration agreement?
clause, my lord, 47.
Page
Page 47, my lord.
Page 47. What is the value of the dispute?
Well, is, my lord, have. All value is there. Total claim amount, my lord, about 2 crore 5 lakh.
2 5 lakhs. So which relevant clause?
Clause
Engineer,
minus-
you said Institute of Engineer.
Yes,
Where is the clause? Institute of Engineer.
yes. There is a clause C, my lord.
And he is demanding 35,000.
Yes, fees,
For what purpose?
for fees for appointing the arbitrator, which is not provided in the agreement.
The institute, it is their mechanism, you know. They used to charge fees.
Okay,
Whoever-
it is their procedure to charge fees.
It is their procedure, you know. The Institute of Engineers, they approach the Institute of Engineers that appoint us an arbitrator so that our matter can be sorted.
So they approached and accordingly they.
No,
were sought-
instead of now deciding that, why don't we appoint an arbitrator? You agree on an arbitrator
But,
or you want to go follow the
Yes.
procedure only?
yes.
but we have said that since.
No, what
we-
I say, ultimately, dispute is something different. It has to be decided by arbitration. We are still in the process of appointing arbitrators.
Appointment of. Lord,
The agreement say one each by the two parties and the two arbitrators will appoint the third one.
yes,
Third one amongst themselves.
yes.
So now you have failed to appoint the respective arbitrators.
Yes,
So section 11 will be applicable.
yes.
Section 11 is the power of the court, delegated power of the
And
court
my
to appoint.
Clause F is also relevant, my lord. If the claim is less than 50 million, then sole arbitrator will be appointed.
What is million?
One,
Clause F, my lord.
What is million?
Million, my lord.
Million and billion are American calculations.
About
We
more than
go by
five-
lakh and
five
crores
crore-
and everything.
5 crore, my lord.
5 crores.
And list of, it is there, my lord, from list your lordship.
Yeah, below. Refer to sole arbitrator, so good enough.
Or high court list is there, your lordship.
Why don't you do one thing?
well,
We fix a date, you agree upon the arbitrator, will be best for both.
Yes.
We'll appoint it as per your choice.
look,
Possibly that list is containing number of Supreme Court judges,
Yes,
if I am not wrong.
yes,
Only,
High Court judges.
only 2 High Court judges are there.
yes. Because
So we can expand the horizon to any other arbitrator, or it has to be confined amongst that list?
well, I'll talk to them and come back. Only.
It's better you decide. If
Logic.
both of you agree,
Yes.
it'll be very easy for us. We don't have to go to the notification also.
Yes, yes.
As agreed, so and so, we'll appoint it.
I'll
Go ahead.
I like that. Only as regard the procedure they have followed, they approached the institute and they did not. pay the
Understand.
fees. Ultimately, Malad,
Understand the claim is about 2 crores.
Malad, from just
Huh.
one thing I am indicating, from 21 till 23, 2 years have gone by. Ultimately, whenever they file complaint, they will ask for the interest from the date.
No, that the arbitrator will take note. While awarding interest, it is the duty and responsibility of the arbitrator to take note how much interest to award. Interest is not a straitjacket formula.
Got
That due was in 2019, award is in 2023, so interest for 4 years. That is not a straitjacket formula. Interest depends on the conduct of the parties in between. He will decide it.
In the meantime, 2 years have done.
No, we'll provide that. The arbitrator
Yes.
will take note
Yes.
as to the
Logic.
interest that the entitled or payable by the parties, taking note of the facts and circumstances and
Yes.
conduct of the respective parties.
Yes.
We'll put one line.
But Lordship may kindly keep the matter on 7th or 8th. Malad, I'll come back with from the authority.
yes,
I think both of you agree that
Yes.
is best course
Yes,
for you.
yes.
Yes,
Then there is no scope of
Yes,
any
yes.
further litigation. There is nothing. You go ahead with the arbitration.
Yes, yes.
Lodge.
If you're entitled, take your money. If you're not entitled, you reject it.
Yes.
It's stated that. And why do we need so much of pleadings in these cases? I don't understand. It's stated that the pleadings are over and the matter can be given a final consideration. We take a note that this is an application under section 11 of the Arbitration and Conciliation Act. Which year?
21.
19, Act is of
1996.
1996 for appointment of an arbitrator. Clause 3F of the contract between the parties provides that if the value of the contract is less than rupees 5 crores, the matter shall be referred to as sole arbitrator. And admittedly, it is stated that the valuation of the value of the dispute would be approximately rupees 2 crores or above, or slightly above. And accordingly, under clause 3F, a sole arbitrator can be appointed. Both Mr. Or Mr. Dinat agrees to examine the matter and suggest the name of a sole arbitrator agreeable to both the parties. List on so and so for appointment of the arbitrator.
On 10th of November.
Any date. If you go by that list, I think it will be little complicated. It's better you agree with it.
Item 40,
Item 40, I need some accommodation.
Adjourn or prayer room is absentees for secondary.
For secondary.
Yes, sir.
41,
Contempt matter, lordship passed two orders, directed the my lord
Mayor
council.
Chisti Regache to list again on so and so, this continues.
My lord, the petitioner is a widow, retired my lord, 18 months earlier as a regular principal of a college. Lordship may kindly have a look at the judgment of operative portion, my lord, page 16. Page 16, my lord, last paragraph. Accordingly, court after taking into factual census. Event of.
Yes, Mr.
no-
Chisti.
No
Yes,
position.
Lordship, what happened that the director has already written to the secretary, Lordship, because there is a gap of 9 days where one, in that period, Lordship, one, Midhu Pawan Bora has joined as a principal.
My lord,
So
this-
for that gap period, Lordship, director has written to the secretary for what to do, Lordship. Now it is pending before the secretary government. Lordship, that is the-
See, had it been not a widow, we'd have asked you to pay provisional pension.
Yes.
Provisional pension is not applicable for the
Yes.
family,
Yes.
for family pension. Do whatever you have to do. Tell us by tomorrow.
And lordship may kindly think, see.
How will the widow survive? Just tell us one thing. How do you expect this person to survive? Number one, and number two, if there is a gap period, because of whose fault there is a gap?
My lord, there
Because in between, I remember this matter.
Yes,
Yes.
In between,
one under.
you wanted to favor somebody, brought in somebody for a very brief time, and he was, I think, set aside also.
It was set aside and she was
Lordship took care of that.
allowed to join.
If I remember correctly.
Lordship
And-
took care of that period.
Yes,
They are reopening, my
Uh,
lord,
The
by this.
Director of Secondary Education as well as Secretary School Education Department to remain personally present tomorrow. Or in the alternative, appropriate,
secretary is not out of station right now, Lordship. So-
no, or in the alternative, we are giving him, ask him to do it. Nowadays, online can be done. Or in the alternative, appropriate processing of the pension papers be produced before the court. The reason given by the director regarding a gap period of 9 days is no longer acceptable in view of the judgment dated.
Yes, my lord. Judgment dated, my lord, with 7/6/23,
7/6/2023 in WPC
184 of
184 stroke
2019.
2019.
My lord, in that case.
And
your
the director to take note of the said judgment. List tomorrow. List tomorrow.
Document.
Tomorrow,
Mr. Barbara, list tomorrow.
item 42,
Obliged.
Because see, otherwise vacation,
Yes.
another 1 month. Why should we allow a widow to starve for 1 month?
let it on last day, Lordship, on Thursday.
No,
Thursday.
Tomorrow, Lordship, it will be this sort of.
sorry,
Thursday, Lordship.
tomorrow. Yes, something could have done much earlier.
Yeah.
It's not done, that's why. We are bound, deliberately we are putting the pressure.
42,
Yes,
Non-compliance of order dated, my lord, candidacy page 54, my lord. And operative portion, my lord, page 57. Paragraph,
page number.
page 57, my lord, operative portion. Paragraph number 10.
Mr. Padgiri, why did you ignore one compassionate appointment for 1 year? Court is having compassion, respondents are having compassion, but the counsel for the petitioner is having no compassion.
I can
We don't appreciate that.
argue that matter, my lord. Only this matter.
Only when we asked you to do so. You will send some junior counsel who is not even properly briefed about the matter. Don't do it. If you don't like, hand over the brief, we'll appoint an amicus. Lot of people are there. But certain deprived section of the society should not be further deprived by this kind of conduct. The court has a mechanism to take up their matters on their own.
Yeah, I have some difficulty.
No, 1 year, 1 year, you cannot have difficulty, Mr. Padgiri, don't tell me that. And during the 1 year, you must have at least appeared at least 20 times before this court to argue your other matters. So other matters, you have no difficulty, but for compassionate appointment, you have difficulty. If you don't like, return the brief, return to the court, in fact, don't even to the petitioner, we'll take care of the problem. Don't show this, it's a very bad indication. Must be one widow or some deprived person who is seeking compassionate appointment. What is compassion? To be dealt with immediately. And every day matter is listed, you are taking adjournment for the last 1 year. Don't you feel, have any compassion for this person? You may have your reasons, which you cannot ask also for the reason, but that reason is not acceptable. So take note of it. Yes, which page?
Page 54 and operative portion page 57. Paragraph 10, page 57. Paragraph 10, my lord. The said amount shall be released within the outer period of.
The
3
said
months.
amount shall be released. Yes,
Then my lord, communication, my lord, page 59, my lord.
notice 6 weeks.
My lord. Oblige.
Steps, register postage. Yes, which is, page is the order. Hmm? Which page is the order which is violated?
Page number 13, Lordship.
Page number,
Paragraph number 11 and 12, Lordship.
notice.
One of the petition with my lord are junior inspectors in the IEIs in the state. My lord,
Reading's over.
readings over.
Are you hearing it today?
My lord, the only point what I am trying to place before my lord, there is a rule, there are 4 lines.
Mr. Nair,
Lordship.
if we hear complete.
Fine, my lord.
If we don't hear, we fix a date. Which one to do?
Subject to what?
Mr. Kego may be harding.
Sorry,
Mr. Kego may be harding.
My lord will fix it.
some other day. As straightforward list on fixed date.
10th November.
From our side, we have no
No,
difficulty.
because, but if he is having, then why my lord waste time?
Then unnecessary, better
That
assure
should
somebody
not
else. Hmm.
My friend was ready, my lord, I would have.
45.
I for what purpose?
Amendment, Lordship.
Amendment of what?
What is container number, name and address for container number 1 and 2 inadvertently clerical mistake, Lordship. So I may allow to container number 1 and 2, Lord.
Respondent number 1 and 2, you want to correct them
Yes, Lord.
in contempt case?
Yes, Lord. Clerical mistake. Technically,
Heard Mr. R.C. Das, and counsel for a petitioner, by this interlocutory application, the area of respondent containers in contempt case number 292/2023 is sought to be corrected. According the what was earlier, what was wrong?
Lordship, page number 4, Lordship, in my contempt petition.
What was wrong there?
It's a clerical mistake, Lordship. Is that
What kind of clerical mistake?
page number 4, Lordship. Name and
Hmm.
designation, Lordship. Designation.
Okay.
ACS I have written, Lordship, and particularly IAS, Lordship. And address of the something, Lordship, Department of
Sir,
the.
who had corrected it already?
Manually corrected, Lordship, but
Who had corrected?
so as per the direction of this board, Lordship, corrected initially. Last occasion, Lordship.
Yes, you were. No, no, that to correct everybody still make it like. Should correct the new matter by filing introductory application. Mhm. No, who had tempered here? এটুকু কোনে করেছে? Just check up.
So we have correct, but as per the direction.
No, no. Direction is after filing IA. You are not supposed to touch the court record.
Initially, I have had one IA also, Lordship, and that IA, I have withdrawn Lordship as because Lordship, so I have heard the.
No, no, who had done that correction with all the whitings and handwriting and who had done it?
So, we have corrected as per the.
Why, how can you touch it a court record?
As per the direction. of the school.
Which direction?
But previous order reflected Lordship.
Look at the previous order, what it is. Look at the previous order, not there, first one on the order sheet. Please read the order.
It is correct the name and address of the convert of the service note. The filing the.
By filing introductory application.
I'm sorry.
That means you are not supposed to touch it. You were tampered with the court record.
I'm extremely sorry.
Now, after that, you are filing this IA. What order should I file? That the court record had already been corrected by tampering with it, no order required. That's what, that's the order I can pass now.
Bottom of the initially I have one IA also filed. So there.
Mr. Das, you have created a mess. You file one more petition, we'll give you liberty, withdraw all this, close everything. File the correct one.
I'm extremely sorry for that.
No, otherwise you have to go in an inquiry. How the court record has been tampered, it will be in bigger difficulty.
So I'm extremely sorry for that.
You're sorry cannot.
So,
Have you realized the situation you are in?
so I.
Today, there is an IA for correction. And somebody had already corrected it by hand. So what order should I pass today in the IA?
I'm extremely sorry.
Yes, sorry, we understand. But what the court is supposed to do now? Best course is withdraw everything, close everything, liberty, file a new one.
Yes.
Otherwise, you'll be in trouble.
Yes, sir.
Then we have to cause an inquiry, ask the registry who had tampered with the court record then.
Yes.
Hmm.
Yes.
The petitioner is allowed to withdraw the contempt petition with liberty to file a fresh view of the order, IA closed.
Yes. Possibly.
Otherwise, it will be difficulty. And please don't do that.
Yes.
And I never pass that order. Even if in a given case I pass, I always say in presence of the registry.
I'm sorry.
Please.
46 per hearing.
File a new one with the all correct address, we'll issue notice. We'll ignore that.
The last occasion, is directed the
Just a minute.
additional PP to procure the original record.
Yes. Where is the PP? B Sharma. B Sharma সবসময় করবো। Let the PP come.
47.
Mr. Zakir, You are for the college authorities. Who represents Mubarak Hussain? Yourself. Are there two signatures issued by Mubarak Hussain? You have filed an affidavit saying no. That is not your signature. Page 17 and page 92, I think. 92 is not your signature. 17 is your signature. No. We don't know about her name. 17 and page 92. 17 is your signature. 92 is not your signature. Mubarak is alive still.
Hello,
He filed an FIR and unit proceeding is also pending. During the course of the proceeding, I can put them for hearing, need some to understand.
By whom? By whom? Hearing by whom? You said file a petition for hearing. Who will hear?
Oh, yeah. At the petitioner level, Philip Chandra. Philip Chandra, Hanoi was not made in that proceeding.
Anyway, let the PP come. We'll get the records. We'll find out.
yes, my lord.
We'll find out whose signature it is. If it is yes, we'll proceed. If it is no, we'll proceed.
We have papers which was signed by him, also certificate given to me. But then, my lord, the affidavit filed by him.
Mr. Mohanto, normally we may not have gone to this extent. But the name Borkhetri College is not only a name of a college, it's carries a meaning of its own also.
Yes,
So everything has to be
it has to
inquired
be
now. There's no other way out.
exactly, my lord. Because a
Next.
person is creating a havoc there.
That's right.
Now, whether who is right, who is wrong, that has to be seen.
That's right.
That is
So
why-
we'll go to the
I-
core of the
I-
allegation.
I want a copy of the affidavit filed by them. Theirs has not been served on us.
Okay.
That only. And then we
Give
may
a
have to
copy of the,
counter to it.
give a copy
Alright,
to the respondent also.
Find this, what the affidavit of the copy. I will share.
Next, next to Niki. Oh, sorry. 47. For it is not to respondent produced records.
Readings are complete, my lord. The
Yes.
Lordship, can it be taken up on the after tomorrow, Lordship?
No.
On the small law point is involved, Lordship. in
You
this
please
case.
argue, we'll hear you. We have enough time today. In fact, we have found out time for you only. We are in item number 40 something.
47.
We are still before 12:30. We'll hear you. Enough time.
That actually Mr. Mozumdar is conducting these days. Today he is not,
He is also welcome.
not well.
he is not keeping well today, Lordship.
So he cannot be welcome because he is not well. I don't know now what to do. What is happening to Mr. Mozumdar? R. Mozumdar?
Lordship.
Quite frequently, he is not well.
Last, Lordship, last 1 month, Lordship, he is not keeping well.
Uh,
Yes, Lordship. That frequently suffering from the high fever. After 1 or 2 intervals.
I'll have to inquire.
And submit report. No, inquiry means report. So he'll make an inquiry and submit a report.
For my own. My own satisfaction.
It's stated to Mr. R. Mujumdar is unwell today.
After meeting.
They will state out.
48,
48 years.
My lord, they should be submitted
Which-
reports. What-
Original completion certificate lied against. the petition.
repairman, he's on late.
Huh?
Big will be repairman, he's on late.
49 for motion.
You are the PP. Where are the two originals? Page 17 and page 92 document
Lordship.
originally seized by the,
Yes,
we wanted a copy of them.
Lordship.
Where is it?
Lordship, as per Lordship's direction, I have communicated to the OC of the concerned police station, Lordship. Now, Lordship, later on, we came to know that the case has already been charge sheeted. And all the original documents are part of the
We know it is charge sheeted.
Lordship.
Get it from the court, make an application.
Lordship. Lordship, it will be work by Lordship to call it to the registry, Lordship, because the concerned police station cannot, Lordship, obtain those courts, Lordship, because it in the court custody, Lordship.
Production registry, kone ane. Pending matter registry ane niki. Niyam to ki. Ask the registry the procedure.
Yes.
We'll verify the procedure. If it is registry, we'll ask the registry. 49. Oh, we'll take up after some time. Let us get the information from the registry. If registry will modify the earlier order. And put it in the registry. Yes, Mr.
Please, your lordship, my lord.
My lord, by order dated 29/5/2018, on page 24, the petitioner was allowed to act as the insurance headmaster of the school, my lord. Gulimara LP School, it is in, my lord, Dibrugarh, my lord. And
What is the name of the school?
my lord, Gulimara
I
LP.
think
That's the problem, my lord.
that must have happened to you, due to the name.
Page 24, my lord.
Qualified report, so to issue nature, is setting aside the order dated 19/9, which page, 19/9?
Yes, the 33, my lord. By this interim order, my lord, without issuing any show cause, my lord, nothing.
Just a minute.
My lord.
The District Elementary Education Officer Dibrugarh to provide the information to the court as to why the order dated 19/9/2023 was passed, allowing the block elementary education officer to be the in charge head teacher of number 2 Gulimara LP School, in a situation where the petitioner was earlier allowed to be the head teacher. Till such information is provided, the order dated 19/9/2022 shall remain state list on swing.
Deeply obliged. Obliged.
We are not issued notice, so we want the reason.
Serve the extra.
Extra copy.
Obliged.
Yes, 50.
As per last order data.
Produced the order details in reference and.
I'm going to file affidavit.
Do you file your affidavit?
Today, I will.
Mr. Constable and element states that the affidavit as indicated in order 29/9/2020 would be filed
Today.
in course of the day. List on swing.
51 for orders.
Yes, Mr. Khondapur.
Here, my lord, petitioner is a teacher of ME school, language teacher. His petitioner is the language teacher of ME.
51.
51.
Today, what is to be done?
Uh,
So only no affidavit also. And Mr. SMT Chisti Lanka elementary place for 4 weeks time to file affidavit. They start for 4 weeks.
Same ground, your lordship already set aside the ground.
But
Same order has
what
been
to do? Notice is issued.
I notice has issued, my lord.
Had it been motion, I would have heard you in a different manner. But once notice is issued, on the second day, I cannot stop them from filing the affidavit.
Service also, my lord.
Sorry.
Service upon the respondent number 3, my lord. That has been.
Okay.
So let it be for admission.
Service is over on response 6.
My lord.
Check up.
Office note 1210. Portal journal.
Postal track doesn't serve you any purpose.
After vacation, in the meantime, my.
Take, serve Dusty.
After vacation, my training.
No, why I am saying postal, this tracking of postal, I don't know, nowadays it is adopted.
In the meantime, yes.
If the order is in your favor, that man is going to come and say, notice was never served on me.
Yeah.
Everything has to be set aside.
Yeah.
If it is against you, he'll be very happy. But otherwise, postal tracking is not a service of notice under the law. It is only an indication.
Then that's the.
To make the process complete, you go and serve Dusty.
Yes.
The petitioner may serve Dusty on the respondent number 6 to the registry of the court and thereafter file affidavit. Once Dusty is served, he cannot come out of it. He can never say I was not served. But these indirect methods, the General Clauses Act 27, postal tracking, these are not conclusive.
Here, well, petitioner or respondent number 6 or 5, own system.
No, you offer the Dusty before one the Dusty may be offered in the presence of an independent witness.
I am.
Your sister may refuse, you don't know.
I am.
Take a independent Gaubura or somebody or whoever it is as a witness.
Your lordship may be through that BO also. Can I start?
That is also not a service. It will be a service on the BO. For the BO will have to file affidavit whether it is served or not.
I am. also.
Timing item 2.
Please, your lordship. Until I file an affidavit in my personal case,
Hmm.
personal of the last order.
This is what kind of petition? Compassionate.
Yes.
Same. Same with Mr. Padgiri. You are allowed 2 years to go by.
File an affidavit on deposition in this matter.
No, we don't want affidavit all the way, but why do you treat these people in this manner? If you don't like the brief, if your terms with your clients is not good enough, return the brief. Or else you return the brief to the court. We'll take up the matter, but this is very unfortunate in them. Compassionate appointment, somebody needs immediate attention. And you don't proceed with the matter for the 1.5 years now. Where is the compassion? You may have your reason not to proceed. If that is the reason, return the brief back. Once you hold the brief and don't proceed, you are almost, in a way, compelling this litigant, making her unable to proceed in any manner. Neither you are returning the brief nor you are doing the case. Why? Something must not have been given to you as required by you. Should you refer to the Bar Council? Don't you think this is a bad habit? See, all of us were also lawyers earlier. We also understand. But that doesn't mean you will not do the case for almost 1.5 years now. Because you are having a difference of view with your client and you will not even return back the brief also, so that she can proceed to somebody else. This is a misconduct. It's a professional misconduct. Mr. Vijay Phukan, what do you say? Is it a good thing for a lawyer to do?
Will be in the now
No, we understand. You may have good reasons for doing it, but those reasons cannot be justified in law. See, this one simple matters like family pension, compassionate appointment. These are all the deprived people who need some immediate attention from the court. Is it not so? A huge matter, we understand. Some commercial matter, this, that, okay, you'll like keep it pending. Commercially, it is not viable for you, is we understand, but these small matters. If you don't to tell us, we'll appoint a legal aid counsel and get it done. Give back the brief at least. Just see the number of dates. Fifteen 6/2022. Hmm. 21/6/2022. No one appears. 24/8/2022 adjourned by the petitioner. 25/1/2023 adjourned by the petitioner. 24/7/2023 adjourned by the petitioner. 3/10/2023 again adjourned. Why did you do it? Why did you do it? Why are not even allowing the matter to be moved also for 1.5 years? What did you say in your affidavit? Sorry? So your personal problem is greater than the personal problem of this litigant. Let the litigant suffer. And what personal problem? Because Mr. R.A. Chaudhary, I have seen you a number of days appearing before this court in other matters. It's not that for 1.5 years you were totally ill or something that you could not do. Nothing like that. Repeatedly you appear before the court in all other matters. Why did you ignore this matter? We are feeling sorry for the litigant. Not
More particularly, since the
compassionate means these people are in such a desperate situation, they need something. And they at least want a finality in their claim. If you get, give it to me. If I don't get, I'll look elsewhere. They'll go looking elsewhere if they don't get it. Yes, we'll pass our orders. You please take your seat. We don't want your assistance. Did I put your name? That I heard you. I should put your name. Then you will go to the person and again cause difficulty to that person, that today I got the order. Now you do the further requirements. Heard Mr. R.A. Chaudhary, Land Council for a petitioner also heard. Astutia for Elementary Education Department, Mr. P. Sakia for Deputy Commissioner Hailakandi. Husband of the petitioner Rafiq Jamal Loskar, who was an assistant teacher in the Sorospur Pathartali LP School in the Hailakandi district, died in harness on 19/7/2010, and on his death, the petitioner submitted an application for compassionate appointment on 13/9/2010.
As per page 53, my lord, application submitted on my lord 28/2011. Page number 53.
That's what we're trying to look. But annexure 3 is there, no? As the application of petitioner was not given its consideration, WBC 7563/2013 was instituted, which was given a final consideration by the order dated 3/1/2014, requiring the application to be placed before the concerned authority as per law, meaning thereby before the concerned DLC of the district concerned. Thus, the order impugned dated 11/10/2021 of the Deputy Commissioner Hailakandi shows that the application was placed before the DLC in its meeting of 5/10/2021, but was rejected on the ground that the employee died on 19/7/2010 and the application was made on 28/2011, that is after a period of 1 year. It is noticed that the annexure 3 to the writ petition shows that the application is dated (13/10/2010). And if it is so, it was well within the period of 1 year from the date of the death. No relevant material is available as to what application was considered by the DLC for that. So in order to be recorded that the application is dated 28/2011 and therefore liable to be rejected on the ground of being submitted after a period of 1 year. Without going into the said question, we noticed that in the earlier proceeding, the said stand was not taken by the respondents. And there is a direction of the court to place the application to be considered on its own merit. From such point of view, the DLC would be precluded from rejecting the application by taking a stand that it was submitted after a period of 1 year. Moreover, it is no longer a res integra that the requirement to submit application within 1 year is a directed requirement and not a mandatory requirement, and it by itself cannot be a reason to reject an application. Considering both the aspects, the rejection by the DLC in its meeting of 5/10/2021 is rejected, remanded back to the DLC to consider the application commission on its own merit and as per law to be placed before the next available DLC.
Timing item 3.
Your client could have been employed by now had you done it on the very first day. Yes, same. Why?
My lord, this case has been placed on 16/3/2013.
Sorry.
DLC had considered the case, my lord, 16/3/2013 and rejected, my lord. Due to, my lord, petitioner has not submitted the financial status, my lord, along with the time.
Yeah, where is the which page?
My lord, as per my instruction.
Yeah, pretty matter is adjourned to be, no, there is no requirement of any, where is the order of the DLC?
I am seeking for placing the before the DLC.
And according to you, it was placed earlier.
Yes, sir, 2013, my lord, yes.
Give him a copy. You challenge that one. Heard Mr. K.R. Padgiri. Mr. Padgiri is same with you. Almost 1 year you have kept it pending. Don't do it.
I remember, my lord.
We are going to refer to Bar Council if it happens again. Especially this family pension, compassionate appointment, these matters. If you don't move a petition for almost a year for no reason, it's something unacceptable. No, nothing.
Side of the matter, my lord.
Nothing like that. Reasons are apparent, Mr. Padgiri.
Sorry.
When a person behaves in this manner, reasons are quite apparent. Don't tell us it. Also, and S2T. The father of the petitioner, Praveen Chungkrang, what was he doing?
Praveen Chungkrang.
No, what was he doing, Chungkrang? What was the father doing? Forgotten.
Praveen Chungkrang.
In what post, which department he was working?
Yereki ME school, my lord, he is assistant teacher.
Where did you state it?
I know this knowledge stated, my lord.
Is the synopsis supported by affidavit?
No.
Then
No.
how can you rely on that? Was an assistant teacher
Assistant teacher.
in which school?
Yereki ME school under Lokhimpur.
In KME school, in Lokhimpur, died in harness on 1/7/2002, and on his death, the petitioner submitted an application for compassionate appointment on, when did he submit?
29/2002, madam.
29,
29/2002.
29/2002. This writ petition is instituted by raising a grievance that the said application was not placed before the concerned DLC, but Mr. P. Saikyal and counsel for the Deputy Commissioner Lakhimpur has obtained the information that the application was placed before the DLC in its meeting of
16/3/2013.
16/3/2013, and it stood rejected in as much as appropriate materials regarding financial status of the petitioner was not provided. As the application was earlier placed and rejected, we see no further reason to again place the application before the DLC. But however, for the interest of justice, the Deputy Commissioner Lokhimpur to provide a copy of the order of rejection by the DLC to the petitioner, and the petitioner, if so advised, given liberty to approach again.
Item 7,
Kindly page the order dated 11/8/23, madam.
Where perused it? G Pegu Elementary prays for 1 week time to receive instruction. Chikdar. What is the matter?
Madam, my lord, transfer
Transfer.
to from Rangpur Government High School, answer 10, madam.
Hmm,
Answer 10 is 56.
56. Is there any stay order?
No.
Then what are you doing for the last 1 year?
My lord, I am preparing before deputy inspector of school.
No, no.
I-
Is there a stay order? It's a transfer order. 1 year has gone by. Is there a stay order by the court?
No.
Then where is the petitioner serving now?
My lord, he is serving before the, my lord, deputy inspector of school. After giving several time of representation, my lord, he could not cover the concerned school, practicing of a school for this joining, my.
No, no. বুজি পোৱা নাই মানে explain in a more easy words মানে এই মানুহজন পুৰণা স্কুলত কাম কৰি আছে নে নতুন স্কুলখনত?
None of them. My.
None of them.
He was not allowed to join, my lord, because of local public.
So he was released from one school,
Yes,
not allowed to join any other school. Give him a place of posting, regularize his service.
It's place of posting is there, my lord, but local public are not allowed to join.
That is not his problem.
Yes.
That is your problem. Why did you
Yes,
transfer him to a place where he cannot join?
Because of local public, my lord,
We are not against the local public, nor in favor. But where will this man go? You transfer him, he is released from his original school. In the new school, somebody doesn't allow him to join. You don't take any action against the public. Now, what will he do? Either take him back to the original school or give him some posting in some other school where he can join. Or you take up with the police and everybody, control the local public, enable him to join in the school where he is posted. Sorry, we don't know, you know. It is for you to take up with the DC, not for the DC to so much to come into the matter. Did you take it up?
my lord, we have communicated.
But you pay the complete salary. I don't know from where you pay. You enjoy the salary, stay at home. Heard. Your name? SI Talukdar, Land Council for the petitioner. Also heard Mr. Ganesh Pegu, Land Council Elementary Education Department, and Mr. P. Saikia for the Deputy Commissioner,
Yes, my lord.
Kachar. The petitioner Mujibur Rahman Borbhuiya, who is the headmaster of Rangpur Government Senior Basic School, was relieved from his place of posting by the order dated 19/2/2022 of the Deputy Inspector of School, Kachar. In order to enable him to join at his new assignment at Practicing Government Senior Basic School, Udarbond. Full stop. This writ petition is instituted in a circumstance that after being relieved from his original place of posting, the writ petitioner is not allowed by the public concerned to join at his new place of posting at Practicing Government Senior Basic School. In the circumstance, the petitioner is neither holding his original place of posting nor he is allowed to serve at a place where he is transferred. If the local public is not allowing the petitioner to join at his new place of posting, it is the responsibility of the respondents in the elementary education department to ensure that proper circumstance is made to prevail in the school where he is transferred so that the petitioner can join. If necessary, taking help of the deputy commissioner, etc. But on the other hand, if the respondents is unable to bring the situation under control, it is for them to take a decision to either allow the petitioner to continue in his original place of posting or to give him a new place of posting where he can appropriately join. It appears, prima facie appears that the petitioner is in the present situation because of lashes on the part of the respondents rather than any lashes on his part. It is stated that because of the aforesaid situation, the petitioner, are you getting your salary?
Yes, ma'am.
From where?
From he is now attending in DIOP. Deputy Inspector of School.
DIO school. It is stated that to mitigate the circumstance, the petitioner is now allowed to work in the office of the deputy inspector of school from where he is getting his salary. But he's a headmaster.
Yeah.
You must have made him a clerk in your office. The deputy inspector of school, Kachar, to inform the court on the next returnable date as to in what manner the respondents intend to mitigate the grievance of the petitioner. We have noticed that on several occasions, time had been granted for the purpose, but no information is available. Accordingly, on the next returnable date, either the deputy inspector of schools, Kachar, to remain personally present before the court or provide the court with necessary information as indicated. Response, Vincent. Copy of the order to Mr. Ganesh Pegu.
Item 18.
15 of this. Mr. Kon.
Miller, it's regarding change of law center, Miller, law examination.
Ah.
Miller,
Can it be
my
done?
instruction is that there is no such provision, but section 23 general clause of the act, Miller. It will be in their aid. Since we understand, Miller, the. safety and
What was the
security-
background situation?
Lordship, that petitioner number 1 yielded to the petitioner number 2 against the wish of the parents. And both are the final year student of this.
We understand, Miller,
So my lord,
sensitive.
he came to the Guwahati court to appear in the exam. So there might be her family member disturbed
No, petitioner eloped with somebody.
with petitioner number 2.
Petitioner number 2.
Yes.
She is a law student in which school, college?
Final year law students.
This school.
School of
Guwahati.
Guwahati.
Now where do you want to go?
Now they want to go Dhubri. Both of them now residing in the.
Dhubri. So if you come to this school, somebody may.
Or any other law college lordship, even
Only one thing, Miller.
Other than Guwahati.
other than Guwahati, even it is in the Borpetal also, they can arrange.
No, better do it in Dhubri only instead of coming to Borbeta.
Only one thing, Miller, that it will open up floodgate, Miller, flurry of application, Miller, for changing that center. So, Miller,
Understand.
it's a exceptional.
When
case,
is the
Miller.
examination?
Examination
month of
will
December.
start in the last part of November or first part of then
December.
December. lordship.
We'll list it immediately after vacation, see what can be done.
So that form fill up
Mhm.
part lordship.
We don't want a student to suffer also. At the same time, we have to respect the laws also. We just can't, in a random manner, we can't say that give everything.
And
Is there any provision to relax the rule in a given circumstance?
Lord, that section 23.
Do one thing. You make an application to the Registrar Guwahati University. We'll keep it pending.
Lordship.
Because if it is against the law, we cannot direct them. It will be not be proper. Because our direction will become the law from tomorrow. So everybody will come and take a disadvantage. This is the order. But as a special case, in after if your registrar can do something, Then everybody will have to come to the court with a special case, not on a regulation case.
I will submit a representation before the register. And,
Now, you are from Dispur.
I am from the district.
Are originally from Dispur. Your parental home is in Dispur.
District.
Moment to come to Dispur, they are going to get hold of you.
Petitioner number 2 is of.
Is of Dhubri.
Earlier she stayed in state home Jalipati.
But if this girl is trying hard to have education, we should encourage her also, right?
That representation.
The petitioner, who is originally a student of the LLB course in the Dispur Law College at Guwahati, had got married to petition number 1 and married the petition number 2 in an situation where it was unacceptable to her parents and is presently residing at Dhubri. The petition number 1 expresses apprehension that if she appears in the second year LLB examination, final year LLB examination from Dhubri, from Dispur Law College, because of the aforesaid circumstance, she may be at some disadvantage. In the circumstance, the petitioner may make a representation before the Registrar Guwahati University for his examination as to in what manner the grievance of the petitioner can be mitigated. We have been informed by Mr. P.J. Phukan, Learned Counsel for the Guwahati University, that under the rules, such change of center is not permissible. We respect the view of the Guwahati University as expressed through Mr. P.J. Phukan. But in the peculiar facts and circumstances of the present case, where on one hand, it's a matter of attaining education of a girl student, and on the other hand, if she is compelled to appear at Dispur Law College, she may be at a disadvantageous situation because of the circumstances noted above. The registrar may take a, what kind of view? May take a,
Decision, my lord.
may take a rational view on the matter.
Most of life.
Now they are receiving
List on so and so, the representation be submitted for treat, and the registrar may express the views before the next returnable days.
they are residing in the South Salmara Mankasa instead of.
South Salmara Mankasa.
Most of life.
Granted adjournment. Definitely, Vishwa.
This is that matter which pertains to appointment of in-charge principal of B.Ed College, Mongoloi. And on the last occasion, the record of the earlier petition that was filed was called for.
Yes.
Lordship, before you, Lordship peruses that record, may I just make one submission? They were relying on a document pertaining to the year 2017, and the respondent number 4 was brought into the college as a professor. And Lordship had observed that that requires to be challenged. Lordship, why we did not challenge that order? If your Lordship kindly takes up page 48 of my petition, the document. This is a notification dated 29 February 2020. This says that Tapan Kumar Sharma, senior lecturer, died Udarbhan, now serving as College of Teacher Education, Mongoloi, Dorong district, has been allowed to hold the current charge of IC principal in the same institute in addition to his normal duties along with Pinachet. This was under challenge in that writ petition.
In which petition?
In the previous writ petition which we had filed. And that
What happened to the previous
yes,
petition?
that was closed because in view of the fact that in the meantime, the regular principal was appointed.
in accordance. That order is at page 50, by which the writ petition was closed.
How appointment of regular principal took away the cause of action of the earlier writ petition, that it has to be closed? When do we close a petition? When the matter does not need any further adjudication. But if the core issue requires a adjudication, just because somebody is appointed a principal for some period, the cause of action doesn't go away. So you ought not to have withdrawn that petition. By withdrawing the
We
petition,
did not withdraw, we did not withdraw.
then what
It
happened? You
was
said you
closed, The
withdraw.
order is at page 50, Lordship. Page 50.
But you should have insisted upon that it should not be closed.
We had.
The
paid for
Learned Counsel
adjudication.
submits that a petition has filed challenging the appointment as the in charge principal. You are challenged as the in charge principal.
Yes, in charge principal.
We are asking you, there are two different services.
Yes.
Okay.
Yes.
One diet service,
Yes.
one city service.
Yes,
Fine. Respondent belongs to city.
diet. Diet service.
Acha, now it's in CTC.
No, she's still in diet. That is what I'm trying to submit before the court. The
Originally, respondent
Originally-
belongs to
Diet. He's originally also and currently also he belongs to diet service.
diet.
Yes, Lordship.
So he's made the in charge now.
Now again, he has been made the choice.
Why are we aggrieved?
Lordship,
Then what is your ground of challenge then?
we are challenging his appointment as IC principal mainly on the ground that he does not belong to the city service, in short, the city service. He belongs to
No,
the
no,
diet
till now
service.
I'm not very clear of your facts. This dispute is regarding in charge principal in diet or in CTC?
City,
CTE,
Lordship.
okay. Now, they have produced a document. In
Yes.
2017, this man was brought to the CTE, I think. Okay. If diet and CTE are two different services having their own independent channel,
Lordship.
the respondent number 4 having been brought to the CTE, unless you challenge it, if he is legitimately in the CTE stream now, he's entitled to everything as a CTE.
Lordship, that is what I'm
You
trying-
cannot challenge a part of it that you cannot make him the principal, but at the same time, you can allow him to continue in the CTE.
Lordship, what I'm
It's a
trying-
diabolical, then
Lordship,
this
what
stand
I-
is diabolical. You cannot take it.
No, I'm not taking it. But what I'm trying.
Either you challenge the whole thing.
Lordship, what I'm trying to submit is that he has never been brought into the city service. He's still in, he was and still is in.
No, no,
diet.
he says he's brought to city.
Yes, because, Lordship, one more document.
2007,
Lordship,
and I have also produced one garrison list
Huh.
by SCERT.
I think I last date I had seen that one. I read it, if I remember.
This garrison list was not.
Okay, gradation is not there, but you
one
produce
garrison list
something
is there, Lord.
that he is brought to the city.
Yeah,
Yes,
2007.
this one.
Lordship brought to the city, but not the service.
He is
of-
transferred and posted.
And Lordship will see the subsequent
The
phases.
moment somebody, this is definitely not a deputation. He's transferred and posted.
Lordship,
Moment somebody is transferred and posted, he becomes a part and parcel of that service.
Lordship, what I'm trying to
If-
submit is,
We have to accept your contention, then somebody has to challenge this order that he cannot be transferred and posted in city.
Lordship, that was an interim and the affidavit in opposition that was filed by the commissioner and secretary. That is what substantiated the notification of 29 February 2021 that the person belongs to the diet service. That is why we did not challenge it because he was never brought to the city service. That is what the notification,
In which page is that one? You are referring something?
the notification.
2021? Just now you
affidavit-
said some
affidavit
2020.
in opposition, which was filed by the commissioner in the earlier round of litigation.
But how can we rely on that?
Lordship, there, we have brought that on record by,
See, every litigation has to be decided on the pleadings in that litigation. In some previous litigation, somebody filed some affidavit. That affidavit will not be the basis to determine this litigation.
Lordship.
You
what about
produce
the-
something of this
yes.
litigation.
Then Lordship, the page 70, the gradation list of diet service at page 70. The present gradation list,
Page 70,
page 70,
70.
yes, 70. This is the notification dated 30th June 2023, by which the final gradation list, present gradation list has been published. Senior lecturer of diet, and his name is reflected at page serial number 50 at page 74.
What is this pursuant to the order dated 22 in Tajuddin? What is Tajuddin? Tajuddin and Isop.
The gradation list was under challenge.
A fresh gradation list in the cadre of so and so. In view of the submission of there were some. But this one contains the name of that person,
Respondent
serial
number
number,
At page 74, serial number 50,
serial number
50, 50.
50. Yes, why is
This
it?
is a Gaddison list 2023, Lordship.
Hmm.
Prior to that, Lordship, one Gaddison list was prepared by the SCRT for teachers training colleges, Lord. Here,
That's
Your
it.
Lordship, I have
Hmm.
produced that.
Teacher training college, but that's city.
CPA, Lord.
Huh.
That document is there, Lordship. Your Lordship. 1-2 page.
So his name appears in both the lists.
Lordship, it was by mistake, it has been, his name has been included. his-
In the diet.
Yes, Lord.
You please look into it. If it is mistake, you tell
May I
us.
submit, let them file an affidavit stating whether this person belongs to the diet or the city service, because. in
No,
earlier
draft gradation list of professors in city, his name also appears there.
the
Lordship,
main- no,
kindly
but
see
the
the
main-
remark follow.
The main list, Lordship, the final gradation list of professors, Lordship, we have enclosed here, and his name is not reflected there.
What is not
Page 35,
reflected?
Lordship. Page 35, if the Lordship will read it.
You do one thing. Who is the head of this department? SCRT?
SCRT is the directorate, Lordship, one government.
No, no,
government affairs.
let us issue a direction in view of the two different gradation lists. She is relying on one claiming that he is the, you are relying on the other one claiming that he is this one. Let the authority take a call whether this man is in the service of diet or is in the service of city.
Yes.
Let there be a finality to that thing. If it is in diet, he cannot be made the in charge of the city. And if he is in city, he'll be in city.
Two documents only I have to place, like one is page 43, Lordship, writ petition,
Page 43 of what?
writ petition.
Petition.
Lordship, this is a representation filed by the petitioner himself, Lordship. Lordship, I kindly see.
Sometime back, this one situation had arisen in respect of Guwahati Medical College about 10-15 years back. Same thing happened. One person, you have two services, one that medical college service and one those health state service. One man from one service was brought to the other one and some confusion was there. This always happens. If somebody from one is brought to the other, two issues are there. Firstly, whether he is brought to the second one or remains in the original one. Two, whether he could have been brought. Two issues.
Yes, sir.
Only one line, Lord. Serial number 1, Lord. Page 43.
Hmm.
This is his representation, Lordship. One, Mr. Tapan Kumar.
So who is the Hemanta Tamuli
Yes, Lord, he is the petitioner.
petitioner with
Serial-
reference to the
Serial number 1, Lordship. Tapan Kumar Sharma is a new incumbent in the College of Teacher Education, Mongoldoy. He joined his institute August 2017.
Hmm.
Now, can she be allowed to deny this fact, Lordship? This is her own statement.
No, we are not denying
That
this.
is
fact.
what-
We are not denying.
He is an employee of City Lordship since 2017. Today, when he has been given the post of in-charge Lordship, can he be denied that Lordship? And most important, Lordship, eligibility criteria says 3 years of professor Lordship.
It doesn't say this way or that way.
Lordship.
3 years of professor in city.
Yes, Lord. And he was appointed as a professor in the year 2021.
They don't have the qualification as yet.
Lordship, my prayer is that if if I do not have fulfilled the eligibility criteria of 3 years as professor, I may not be given the chance. Let someone from the Assam State Council of Education, Research and Training Service.
This is
post
not a
the post.
PIL.
That- Lordship, that,
See, this is not a PIL.
and.
Every petition under 226, unless it's for a writ in the nature of quo warranto, or it is in the PIL, there must be a locus of the petitioner, number one. Locus of the petitioner means because of the impugned action, howsoever illegal it is, a legal right of the petitioner must be violated. So if the petitioner does not have that right, there cannot be a violation of that right.
Lordship, in other colleges,
Understand.
there are other colleges also. There are.
If somebody else comes before the court, will entertain this.
Lordship, in the other, in the list of
Madam Borgohain,
professors,
if anybody who is duly qualified to be the professor of 3 years comes to the court, raises the same issue, we'll ask Mr. Naik from a different point of view.
Lordship, the list.
But now, why should a writ petition be entertained on behalf of a person whose legal right is not violated? If we entertain a writ petition and do not look into the question of locus, whether your right is violated or not, tomorrow every man moving in the street will notice something illegality going on somewhere, file a writ petition, there one illegality is going on. Then move around to another place, find out one more illegality, find one more petition. There are some illegalities going on.
Lordship, may I pray?
Therefore, Supreme Court has termed the coin busybody. That one whose right is actually not violated, but he is interested to find out where legal rights are, where illegalities are taking place.
Yes.
These petitions should not be entertained. There are
May I
judgments by the Supreme Court.
Lordship, let it come up after review. I'll seek instruction from the client whether he wants to pursue with the writ petition. or not.
Definitely, because every illegality, Mr. Naik, a writ is not maintainable for
Understood.
every illegality.
Lordship, I accept it. Yes. Please,
If you read 226 language,
Understood.
you see there must be either a violation of somebody's legal right or fundamental right.
Lordship,
Only then.
it's-
In course of the hearing of the matter, Mr. P. Naik, Land Counsel for a respondent in the SCRT, had pointed out that in order to be qualified to be a principal of a CTE, there is a requirement of being a professor for a qualifying period of 3 years. And the petitioner in the instant case does not have the qualifying period of 3 years. Accordingly, Mr. Naik asserts the locus standi of the writ petitioner to assail the illegality in the appointing the respondent number 4. Is it 4? 4 as the in charge principal of a CTE. MSD Borgohain Land seeks for adjournment to examine the matter as to what legal right of the petitioner may have been violated by the impugned action of the respondents. That's all.
Timing item 30.
Mr. Naik, you can take these papers, it'll be misplaced again, and give it on the next date. Yes, ma'am.
Item 30, Lordship, the flag mark, given the flag mark, that is the affidavit regarding Dusty. Lordship also passed order regarding this one, the last day.
Dusty notice is already accepted.
Lordship, on 11/9/2023, Lordship passed an order accepting the.
Sir, we already accepted it. Why are you repeating it again? Now what is to be done?
Lordship, otherwise pleadings are complete, Lordship, they have filed their affidavit, that's one number 2. And we have also given a reply, Lordship. The matter may come up for admission hearing.
Admission hearing.
Admission, Lord. pleading, sir.
Okay, Archie, start. We'll hear it today. You are ready?
Today I am not. ready.
It's stated that the matter, that the pleadings are over and the matter can be heard. Listen.
Much obliged.
Timing 46.
Oh. Hmm. Sign capital. Sign to like no. Suppose the same document is involved in two different litigations. Because it is already used in one litigation. It cannot, other one cannot be solved. নাটকখন তেওঁ চাব পাৰি ভাল। আচ্ছা নহয় যিটো হয়
Lordship, allow me to point out one more document. May kindly take up.
No, first we want to settle this issue, whether it was,
Same lordship regarding the same issue. There are two appointment letters filed by the respondent number 4. One more appointment letter, lordship. Can I place it before you?
page number.
47.
Oh.
If you look into the page 47 and page 92. These two appointment letters are also different, lordship. Examine both.
This is another appointment letter issued to same man.
Same name, same date. The two appointment letters, if you lordship look into page 92 and 47, these two are different. And
Just a
these-
minute. We'll take this note of, first let us say, sort out the original issue.
Yeah.
Same.
But people look into the handwriting and the seal and all. the different.
Who's handwriting?
But the spelling geography is different, lordship.
Why it is different?
And written and the seal lordship, if you lordship look into the signature, seal is above this signature in page 47 and in page 92
Acha.
seal is different. And this annexure was
they have annexed, he has annexed.
in another decision, we have also obtained
That doesn't matter. Your Mubarak principal, why did he issue two appointment letters of the same? Then how page 47 and 92 is different? What do you mean by different?
I never issued any appointment letter.
Okay, according to you, never issued.
Yeah.
Yes, from where did you procure all these documents?
He says he never issued lordship, but he gave me expense certificate lordship in the 2021.
No, after an illegal appointment, you had the experience, he gave you the certificate.
He issued lordship. It is
It doesn't matter.
and lordship, I have an.
Mr. Islam, suppose you never passed LLB. Fraudulently, you appeared before the court as a lawyer for 5 years. Anybody can give you a certificate that Mr. Islam appeared before courts as a lawyer for 5 years. That will not make your original thing validated.
That person must have, that he himself was issued by expense certificate.
He must have issued. So if he have issued, will it make the original one a valid one? No. So that argument will not hold.
That is an part.
Only thing we want to know is the original one actually, it's a fake document or it's a genuine document. That's what we want to look into.
Another thing, lordship, on that lordship, I could not point out the page mark lordship. I come to correct the page by letter on lordship. In my affidavit lordship, actually page mark is 147 Mr. lordship. My affidavit lordship. My affidavit lordship, the respondent of 4 lordship. He filed the submitted the affidavit of opposition lordship. That is in page number 147 lordship.
What is there again, 147?
Yes, lordship, that is my, again, my lordship, I became confusion lordship.
No, what is 147?
This is my affidavit of opposition lordship.
No, we are not interested in
19
a
19
affidavit for the
file
time being.
by record, Lordship.
See, one issue has arisen before the court. The author of a appointment order says before the court that he did not issue it.
Yes, Lordship.
One of the parties is relying on that one to claim their legal right. There is also an admitted appointment order by the same authority. We want to verify whether this is issued or not, that's all. Go step by step, don't mix up everything, you can.
92 page.
We'll pass our order, we'll confer with the Registrar General regarding this thing.
One more, the last occasion.
You make your submission when you hear the matter,
Regarding the original of the petition.
original of the,
Original appointment of the petitioner is with the petitioner only.
okay, you have
It
it.
was not seized by the.
Okay, it was not seized by the
It was
police.
only of the respondent number 4, it was.
That was seized. Okay, understood. You keep it with you till the next day.
If I have, Lordship, please to call for the.
We cannot call.
Then I have
In an appeal against a GR case, we can call for the record, but in another proceeding, we cannot call. At the best, we can say that for that purpose, time being, retain a scanned photocopy in the original record and bring one document here before this court. If one document is relevant for two different proceedings, it cannot be that a document is in one proceeding, so the other proceeding will be stalled. That cannot be the law. This is where we are. Time being.
Timing 48.
48, who is appearing?
Services Officer was directed to furnish a copy of the original completion, work
Huh.
completion certificate. And they are searching on for the particular record of 2010. So come for the.
Adjourn a prayer, Mr. B. Gogoi, Land Counsel for the SSA for production of the original completion certificate.
Immediately after vacation.
Because he says it was not issued.
Yeah, according to him, it was not.
So we want to see the, or if it is there, we'll confront him.
Not-
List on switch.
Production list for motion item 1.
A.R. Bhuiyan. Yes, Mr. A.R. Bhuiyan. What matter is this?
My lord, the matter relates to, my lord, the petitioner wanted to participate in a recruitment process, my lord, for the post of principal in higher secondary schools. My
Hmm.
lord, the
What is the
difficulty is
difficulty?
that, my lord, as per rule.
Direct the two particular as well to do the needful purpose, allowing the petitioner to participate in the recruitment process. As per the office letter. Why are they not allowing you?
No, he doesn't have the qualified service period. Lordship.
Hmm?
He doesn't have the qualified service period as per rule 12. Lord.
Rule 12, my lord, my lord, as per rule 12, as a graduate teacher, I should have 17 years. And as a postgraduate teacher, I should have a 15 years.
Hmm.
Now, what has happened, my lord, when I was working as a graduate teacher of 7 years of service, my lord, I have upgraded or appointed as a postgraduate teacher. My lord.
Understand.
Now, my lord,
So
that-
total is how much?
my lord, postgraduate is now 10 years, my lord. In both count, they are saying that you are not eligible. my lord.
Now postgraduate 10
10
years
years
and
and
as graduate
7 years, my lord,
7 years.
7 years. As per rule 34, my lord, they
Rule
can
doesn't
relax
provide for counting. Lordship.
Huh?
But rule doesn't provide for counting postgraduate and graduate together. Lordship.
No. Once a man is graduate,
Yeah.
had you not made him a postgraduate, he would have been a graduate.
He has to be appointed in a graduate teacher.
Understand, he would have been a graduate teacher. Suppose
Yeah.
being a graduate teacher, a man is entitled to be a postgraduate. Had you refused that one, he would have remained a graduate teacher. And total period would have been 17. But as because he was upgraded, he had gone to a higher one,
much.
he will not be entitled.
that upgraded because he has participated in a that particular selection process. Lordship. He has participated and that's
So
why he was upgraded.
had he not given this less than 17 years, we would have accepted it.
But anyway, Lordship, that process is at the very beginning stage. We have called for the garrison list from the district. That will be prepared, there will be objections, Lordship. It will take time. Notice may go, Lordship, I'll take instruction immediately after vacation, Lordship.
The petitioner admittedly was appointed as a graduate teacher on
My lord, graduate teacher on, my lord. 16th of February 2006, my lord.
16 to 2006 and continued as such up to
6th of April 2013.
6/4/2013.
My lord.
And thereafter, he was
No, my lord, thereafter on 6th of April 2013, I was
Appointed.
as a postgraduate teacher.
and thereafter on 6/4/2013,
13.
he was appointed as a postgraduate teacher and has continued till
Till
date.
date, my lord.
Considering the total length of service, the petitioner had served for more than 10 years as a postgraduate teacher and slightly more than 7 years as a graduate teacher. The respondents are not willing to accept the candidature of the petitioner for the post of principal.
And that is his verbal, he said, respondent has verbally submitted.
The-
That is his statement.
The petitioner has approached this court
Presentation.
upon a verbal instruction given by the respondents that under the rules, there is a requirement of a qualifying service of 15 years as postgraduate teacher or 17 years as graduate teacher in order to be eligible to participate in a selection process for the post of principal. As the petitioner neither has 15 years as postgraduate teacher nor 17 years as graduate teacher, therefore, the respondents have viewed that he would be ineligible.
And his pair is that he has submitted a representation that may be disposed of. That is also another,
Mhm.
that he has submitted a.
But ultimately, if we don't decide it, you are going to just reject it. It's better we decide it. If I only send back the representation, the same thing is going to be repeated and rejected. Again, he'll have to come. So it's better we complete the work. Where is the rules of 2018?
My lord, it is in page, my lord, page 32, lord, page
Page-
32, page 32.
32.
That manual, lord. Recruitment to the principal and procedure thereof.
Page 32 of this book.
It is green,
Education manual, my lord.
it is green.
Or is it something?
Blue color.
Oh, sorry. কি হলো?
Provide material. Yes, otherwise rule doesn't provide for.
Mhm.
Rule 12, sub-rule 3, 2 provides for 15 years of postgraduate teacher. And 4 provides for candidates must have 17 years as graduate teacher in any higher secondary school.
But will that interpretation not be and cause little injustice to the candidates? If somebody does not have 15 years, we understand. If somebody does not have 17 years, we understand. You will be very strict. But had it been only postgraduate teacher, he would have had the benefit of 15 years without requiring 17 years. But he is ready to forego that, saying that I have 17 years of experience, and experience as a postgraduate teacher can never be something below or lower than that of a graduate teacher. So if you take note of that, and we won't allow him because of his component as graduate teacher to avail the benefit of 15 years. But what about the 17 years? Because postgraduate is definitely somebody higher than the state.
Let not issue, let it come after immediately after.
Otherwise, don't you think it will be a little, then from tomorrow, what will happen? You'll never have good postgraduate teachers. Somebody is graduate, he'll continue to stick as graduate. He'll never go for a postgraduate.
And that too also the petitioner of this recruitment process will take some time. And we have also time. He's in a
Provisionally, you accept his candidature, process it. We'll decide this issue.
that period, that stage has not yet come. We have fought for that graduation list from the district.
No, but his
That
name,
graduation list-
difficulty is
Yes.
his name will not be given. Because his gradation list as graduate will be 7 years, gradation list as the postgraduate will be 10 years. So when you seek for this list, his name will never be sent.
And also lawsuit in the, if you lawsuit allowed this, then there'll be the other person also lawsuit.
Yeah,
They
other
may come
persons are there, they are also entitled.
Then her entire process will. lawsuit.
They will also
So,
be entitled.
It's better let it
But,
fix immediately after vacation, let me take an impact on lawsuit. Nothing will happen in these 2 weeks. lawsuit.
Nothing will happen.
Nothing will happen. Lawsuit. It is at a very initial.
Similarly situated.
Because he knows in another case, lawsuit, he has appeared in similar cases.
And he was
No, no,
arguing just the opposite,
Not this petitioner, but in the case.
arguing the opposite.
Yes. in the
I'm not
same-
arguing.
No, no, you're not arguing opposite, but he is that the process is in the very initial stage. Lawsuit.
Milord, here what happens, Milord, along with me, only one candidate in the entire state exists like me, Milord, as per the instruction I have received from the petitioner.
That is competition. Let me have the.
Fine.
from the-
If it provisionally allows me in the graduation, not in the process.
Otherwise, don't you think it will be a travesty?
Fine.
Hmm.
No, graduation list have to
No.
appear, and there will be some.
The
objection
experience
regarding
in
that
a,
graduation list. It will take some
experience
time.
in a higher post
Yes.
can always be included to be experienced in the lower post also.
That is there. But
Hmm.
rule of it. the
Rule,
does
we have
provide
to
for that.
interpret the rule. Otherwise, this will be a travesty, it will be injustice.
Let it say immediately on after vacation, I will get it.
List on so and so for further consideration. की लिखी लो नहीं 16 years लिखी लो हम की लिखी last की लिखी लो.
As the petitioner neither has 15 years as postgraduate teacher, not 17 years as graduate teacher, therefore the respondents have said that he would be ineligible.
The respondents to make submission as to why Rule 12(3)(2)(4), Roman 224, has to be interpreted to be individual, unconnected provisions with each other, and why a conjoint reading of Rule 12(3)(2) and Rule 12(3)(4) cannot be made so as to give combined meaning to the two rules. List on Swenson.
Production list item two.
I issue notice, well, so notice to be listed on Swenson. In the meantime, the respondents may also file their affidavit. A notice different extra copy.
Production list item two.
Yes, Mr. Loskar, what is your matter? We reject it. The reason for mention immediate relief, and there is no relief called immediate relief.
Yeah.
We'll list after the vacation. We asked you to give the reason so that we can examine. You say immediate relief. How immediate relief can be a reason of urgency? That is your perception. His perception may be different. Why don't you tell a reason why you wanted it today? I told you.
Just the petitioner, he is a student. Lordship, and
Sorry.
Petitioner is a student. Lordship. He is a 40% disability of locomotor disability. Lordship. He is a net qualified student. and
Directing
applied-
to issue a copy of the
Earlier petitioner came before this number gave a direction to for examine a special board of compromise. Placed before the petitioner, before the special board.
who are the respondents? Medical Education Director. Where is Mr. Gogoi? B. Gogoi. Come.
He just want to know whether he is qualified or not. Lordship. He appeared before the special board, Lordship, and the special board examined the petitioner. Lordship. As per direction of this honorable court. Lordship.
Where is the direction?
Direction Lordship, finally come page 25, Lordship. Operating part, para 4, Lordship. Page-
24,
Para 4, Lordship, page 26, Lordship.
26.
Para 4, 5 and 6. Last, page 27, Lordship, last para. Lordship.
Who? Arto 9? When Mr. Gogoi comes, we'll take up in the chamber. There's no other matter. You also come over.